Alabama used a new method of execution this month, and the first man to be put to death by nitrogen hypoxia was Kenneth Eugene Smith. Born on July 4, 1965, Smith was found guilty of killing Elizabeth Sennett in Colbert County, Alabama, on March 18, 1988. Elizabeth's husband, Charles Sennett Sr., enlisted Billy Ray Williams to kill his wife. Smith and John Forrest Parker were hired by Williams to help carry out the murder. Elizabeth Sennett was fatally stabbed by Smith and Parker at her Colbert County home. Charles Sennett Sr. took his own life a week after Elizabeth Sennett was killed after finding out he was a suspect in the crime. Billy Ray Williams passed away in jail in November 2020 after receiving a life sentence without the possibility of parole. Both Smith and John Forrest Parker received death sentences. In June 2010, Parker was put to death by lethal injection. Smith was still awaiting execution. Smith was supposed to be put to death by lethal injection in November 2022, but the execution was called off because Smith's intravenous lines could not be connected in time for the Alabama Supreme Court's death warrant to still be valid. Smith and the state reached a settlement in which the state agreed to use nitrogen hypoxia, a secondary technique of execution, rather than the primary method of execution, lethal injection, which is the default method used in Alabama. Billy Ray Williams, a tenant of Pastor Charles Sennett Sr., was recruited by the pastor to kill his wife, Elizabeth Dorleen Sennett, 45 years old. Williams enlisted the help of Kenneth Smith and John Forrest Parker to execute the scheme. Charles intended to reimburse the men $1,000 each for the killing. Elizabeth Sennett was discovered deceased in her home on March 18, 1988. One of the first individuals on the scene, Sheriff Ronnie May, was unable to identify Elizabeth's pulse, but upon the arrival of emergency medical technicians, they were able to locate one. May said that when Charles learned that Elizabeth did have a pulse, he almost fainted. After that, May traveled in the ambulance with Elizabeth, and hospital staff pronounced her dead. Investigators believed the house was set up to give the impression of a home invasion. May recalled having met Charles a few weeks before the incident, at which time they were looking into another murder and had to repeatedly urge Sennett to leave the scene. The names of the suspects were provided to the investigators over the phone. Charles was questioned by investigators on March 25, but denied any participation. He blushed when someone asked him if he knew Kenneth Smith as he was leaving. After the interview, Charles went to his church and met with his sons and their families. There, he confessed to killing their mother and having an affair. After that, Charles proceeded to the parking lot, got into his truck, and shot himself. To minimize pretrial publicity, Smith's trial was moved from Colbert County to Jefferson County, where he was found guilty. By a vote of 10-2, the jury in Smith's first trial found him guilty of killing Elizabeth Dorleen Sennett and advised the trial judge to have him put to death. If less than 10 jurors vote in favor of the death penalty, the inmate will get a life sentence. Though the jury's recommendation is not legally binding, the judge does consider it carefully before determining the appropriate sentence. Smith received a death sentence, but an appeal overturned both the conviction and the punishment. The jury in Smith's second trial recommended a life sentence. However, the judge disregarded their advice and gave Smith the death penalty. In 2022, Smith used up all of his remaining appeals related to the second conviction and imprisonment. On November 17, 2022, Smith was supposed to be put to death by lethal injection. A representative of the Alabama Department of Corrections wrote Smith's attorneys at 7:45 p.m., informing them that Smith was being prepared for execution, even though he had a motion to postpone his execution pending before the U.S. Court of Appeals for the 11th Circuit. Smith had a phone conversation with his wife, and at 7:57 p.m., his call was ended by the prison staff. After being shackled and handcuffed, Smith was led to the death chamber. The 11th Circuit issued a stay of execution shortly afterwards, and Smith's attorneys promptly gave it to the Alabama Department of Corrections. In response, the Department of Corrections stated that they were aware of the stay, but they still kept Smith strapped to a gurney in the execution chamber without telling him or allowing him to consult with his attorneys. The execution team arrived at 10 p.m. and made an attempt to insert an IV into Smith's arm. Around 10:20 p.m., the 11th Circuit stay of execution was lifted by the U.S. Supreme Court. When Smith claimed to be having the needle inserted into his muscle, one of the execution team members corrected him. After placing Smith in an inverted crucifixion position, the crew left the room and came back a short while later to inject him with an unidentified medicine in spite of Smith's protests. Another started poking Smith's collarbone many times with a needle in an attempt to establish a central IV line. Smith's execution had to be put off at around 11:20 p.m. due to the unsatisfactory results. Smith was sweating profusely and breathing heavily, and he was unable to use his arms or walk on his own. This was the state of Alabama's third botched execution in a row. Governor K.I.V. of Alabama ordered an examination of the state's execution procedure after the event. In order to give Department of Corrections employees more time to carry out executions, Governor Ivey also requested that the Alabama Supreme Court modify the state court regulations dictating death warrants. On January 12, 2023, the Alabama Supreme Court gave its approval to the amendment. A second death warrant was issued, directing Smith to be executed by nitrogen hypoxia on January 25, 2024. Nitrogen hypoxia was an alternate method of execution that had never been used in Alabama or in any other state in the world. On January 10, 2024, a federal judge decided that Alabama could carry out Smith's nitrogen gas execution. Senate's family, including her 2 kids, backed Smith's execution on January 24, 2024, after the Supreme Court declined to consider his appeal and turned down his plea for a stay of execution. However, human rights organizations and the United Nations expressed fear that the method of nitrogen gas execution, which has never been used before, could result in cruel, inhumane, or degrading treatment or even torture. Previously, Smith's attorneys contended in the rejected Supreme Court appeal that carrying out a second attempt at execution for Smith following his initial survival was illegal. Smith's last attempt to halt his execution was denied by the Supreme Court on January 25, and that same evening at 6 p.m., his death sentence was set to be carried out. One of the victim's 2 sons, Chuck Sennett, responded by saying that Smith should suffer repercussions for killing his mother, feeling that she was forgotten because of the nitrogen hypoxia manner of execution that was making headlines instead of the woman's murder. The governor of Alabama, Kay Ivey, had previously refused to pardon Smith, which would have permitted Smith's death sentence to be commuted, if successful, to life in prison. 8 hours before he was executed, Smith had his last dinner, which consisted of steak, hash browns, and eggs. His wife and boys also paid him a final visit. Smith accepted his impending death and was at peace despite his fear of the consequences of being executed by nitrogen hypoxia, according to Reverend Jeff Hood, Smith's spiritual advisor, who spoke to the Associated Press. His last words were, "Tonight, Alabama causes humanity to take a step backwards. Thank you for supporting me. Love all of you." Smith was given nitrogen gas for 15 minutes, and after 25 minutes, he was declared dead. It seemed that Smith's death happened 10 to 15 minutes after the gas was given, since his movements stopped at 8:08 p.m., 11 minutes after the nitrogen hypoxia system was turned on. Witnesses reported that Smith appeared to be conscious and that he thrashed violently on the gurney, breathing heavily and salivating for at least 5 minutes before he passed out and was subsequently declared dead. The media was informed by Alabama Corrections Commissioner John Hamm that the alleged observations of Smith convulsing and trembling seemed to be involuntary motions, and that these outcomes were anticipated given the studies done on nitrogen hypoxia. According to Hamm, Smith held his breath for around 4 minutes, which caused Smith's body to react more forcefully. The argument was supported by State Attorney General Steve Marshall, who said that this demonstrated that the nitrogen gas death penalty was a humane and effective method of execution. In a press conference, Alabama Governor Kay Ivey declared that justice had been done and expressed her hope that Senate's family could move on following Smith's execution. Smith's body was then turned over to the Escambia County coroner so that the Department of Forensic Sciences mobile lab could perform an autopsy. There was only one person executed in the month of February. For the 2000 murders of James Mosqueda and Amy Kitchen, Cantu received a death sentence in Collin County. Since then, he always said he was innocent. Ivan Cantu and his girlfriend, Amy Boucher, shared an apartment close to James Mosqueda, his cousin, and Amy Kitchen, his fiancée. In accordance with Boucher's evidence, Cantu requested permission to visit Mosqueda and Kitchen's home over the phone on November 3, 2000 at 11:30 p.m. Boucher did not believe Cantu when he claimed he was going to kill them at their home. After taking his revolver with him, Ivan Cantu left his flat and then drove Kitchen's car when he returned an hour later. His face was swollen and there was something that appeared to be blood in his hair and on his pants. Cantu had the keys and IDs from Kitchen and Mosqueda. He washed himself and Boucher disposed of his bloodied trousers in the garbage. Then, Cantu and Boucher drove Kitchen's car back to the victim's home. While Cantu was searching the residence for narcotics and cash, Boucher observed the bodies of both victims through the doorway leading to the master bedroom. Cantu handed Boucher Kitchen's engagement ring. The pair took off in Mosqueda's Corvette after leaving Kitchen's car sitting in a garage. The remains were found the next evening after the couple had driven to Arkansas to see Boucher's parents. At Mosqueda and Kitchen's home, police were unable to find any signs of forced entry. After speaking with Cantu's mother, police examined the flat where Ivan Cantu and Boucher lived. The bloody pants, ammunition, a key to the victim's home, and Kitchen's car were discovered by police after they obtained a search warrant and searched the apartment a second time. On their way from Arkansas, Cantu and Boucher stopped at his ex-girlfriend's residence, where police also discovered Cantu's gun. The gun's magazine contained Cantu's fingerprints, and the barrel contained Mosqueda's blood. Cantu was detained for the murders. Prosecutors used bloodied pants discovered in Cantu's kitchen and an allegedly stolen Rolex as evidence in the trial, claimed the victim killed both his cousin and his fiancée, a nursing student. Ivan's defense attorney did not call any witnesses or provide any proof of his innocence. The prosecution claimed that Cantu killed Kitchen and Mosqueda, who were drug dealers, while attempting to take cash, Mary Jane, and cocaine from his cousin's North Dallas residence. Cantu, who was found guilty in 2001, said that his cousin was killed by a rival drug dealer because they were at odds over money. Cantu and his legal representative contended in court documents that several of the state's principal witnesses, among them one who has since recanted, gave false testimony during the trial. He was scheduled for execution on April 26, 2023, but the warrant was withdrawn as new evidence came to light suggesting he may have been wrongfully convicted and actually framed for the murder by his then-girlfriend. The woman, Amy Boucher, passed away in 2021, and since then, evidence of her involvement came to light. Moreover, after her death, her brother Jeff started to call the prosecutors and lawyers to say that what he claimed at the trial was not true, that he was on drugs and his statements were all lies. The legitimacy of Cantu's conviction was called into question by fresh information that a private investigator discovered. The victim's Rolex watch was found in his home by police, who gave it back to the victim's family not long after the murder, as Cantu's legal team learned in 2019. The police officer who examined Cantu's well-being at his mother's request after learning of his cousin's death filed a document certifying that she had not seen bloody clothes in Cantu's garbage can at that time. Cantu and Boucher were not home during the wellness check as they were in Arkansas. The Texas Court of Criminal Appeals ultimately dismissed Cantu's request for a new trial without considering the merits of the claims. 3 of Cantu's jurors were persuaded to join the fight to stop the execution by the new available pieces of evidence. Among them was the panel's foreman, who was concerned that the jury was given an insufficient picture of the case. Cantu's supporters committed themselves to bringing attention to the case. More than 150,000 people signed a petition requesting that his execution date be postponed, and to exerting pressure on Republican Governor Greg Abbott to grant a reprieve. Jenna Bunn, Cantu's 15-year-long legal representative, has made several attempts to convince the court to consider the more recent proof. In January 2024, Bunn submitted an additional request seeking that the court reconsider the ballistic evidence that was utilized to prove Cantu's guilt. Based on their own ballistic studies, independent investigators and specialists decided that there is cause for concern regarding the forensic report presented during the trial. Cantu asked in his clemency petition for a hearing and either a commutation to a life sentence or a 120-day reprieve. Ultimately, the petition was dismissed. Efforts to delay Cantu's execution had received the support of faith leaders, celebrities such as Kim Kardashian and actor Martin Sheen, and U.S. Representative Joaquin Castro and his brother, former U.S. Housing Secretary Julian Castro. On February 28 at 6:26 p.m., Cantu got the lethal injection of pentobarbital. 21 minutes later, he was pronounced dead. He started snoring as a deadly amount of the sedative poured into his system. There was a gasp and an eighth snore, and then he stopped moving. Cantu adamantly affirmed his innocence in his final statements. Sister Helen Pregene, his spiritual advisor, silently prayed over him before he made his statement while holding his right hand, which was shackled to the death chamber gurney. These were his last words. "I want you to know that I never killed James and Amy, and if I did, if I knew who did, you would have been the first to know any information. I want you all to know that I don't think that this situation here will bring you closure. If it does, if this is what it takes or have any reservations off in your mind, then so be it." Prior to his death, Cantu expressed gratitude to numerous individuals who provided support in his legal battle, such as his attorney Jenna Bunn and private investigator Matt Duff. Duff created a podcast regarding Cantu's case that raised doubts about certain aspects of his initial trial.
After getting back to Arkansas, Amy told her parents that Ivan had killed James and Amy Kitchen, and the following day she went to the police and gave her statement. And that's the case, the official story in a nutshell, and it does sound about as open and shut as it gets. But here's how quickly it can unravel.
When you look at the state's case, basically, you're looking at Amy Betcher's testimony, and you're looking at the physical evidence, which the state argued linked him to the murder and corroborated Amy's testimony. There was at least an opportunity for other people to have planted that evidence in an attempt to frame Ivan.
All the evidence that was found, the jeans, the socks, the Corvette, the gun, that had all been planted.
Cantu's execution was the first in Texas this year, and one of two planned for Wednesday in the United States. A few hours prior, medical personnel had repeatedly failed to locate a vein to place an IV line necessary to provide a fatal injection, leading Idaho authorities to halt serial killer Thomas Eugene Creech's execution. Willie James Pye, who killed his former girlfriend 3 decades ago, was put to death in March in Georgia's first execution in over 4 years. Pye was born on January 6, 1965. He had at least 6 siblings, including 2 elder brothers. It is said that he was abused and neglected as a child, and that some of his family had a history of alcohol misuse. Due to her husband's periods of incarceration, Pye's mother, who was the family's only provider, had to work between 10 and 12 hours a day, leaving her small children unattended and on their own. Pye dropped out of junior high school due to what was said to be poor academic performance. He was later found to have an IQ of 68, which is lower than the average intelligence of 70. In 1985, Pye was also charged with burglary at the age of 20. He was found guilty and given a 5-year jail sentence. He was freed in 1990. Pye and 21-year-old Alicia Lynn Yarbrough had a romantic relationship that had come and gone, but at the time of the murder, on November 17, 1993, Miss Yarbrough was living with Charles Paquette. Pye, along with 2 friends, 25-year-old Chester Adams and 15-year-old Anthony Freeman, made plans to rob Paquette after learning that he had recently received money from a litigation settlement. In addition, Pye took exception to Paquette's signature on a child's birth certificate, which Pye claimed was his own. The 3 men got into Adams's car and proceeded to Griffin, where Pye made a street purchase of a big, eye-catching .22 pistol. After that, they went to a party where Pye was seen by a witness holding the large .22. The 3 departed the gathering just before midnight and headed in the direction of Paquette's house. Witnesses heard Pye say, "It's time, let's do it," as they were heading out. Pye brought in some ski masks, which the men all put on, and Pye and Adams also put on gloves. Walking up to Puckett's house, they saw that only Miss Yarbrough and her infant were inside. When she noticed Pye attempting to open a window, she yelled. After sprinting towards the front door, Pye kicked it open and threatened Miss Yarbrough with a revolver. They removed the ring and the necklace from Miss Yarbrough and took her, leaving the infant in the house after realizing there was no money inside. The two traveled to a local motel where Pye rented a room under a false name. The three males held Miss Yarbrough at gunpoint while essaying her in the motel room. Miss Yarbrough infuriated Pye, who yelled, "You let Puckett sign my baby's birth certificate." Following their attempt to remove their fingerprints from the motel room, Miss Yarbrough and the three guys departed in Adams's vehicle. Adams turned onto a dusty road after Pye whispered in his ear. Subsequently, Pye commanded Miss Yarbrough to exit the vehicle, forced her to lie face down, and fatally shot her 3 times. Pye threw the .22, the masks, and the gloves from the car as they drove off. Before we continue, please hit that subscribe button. It really does help my channel, and it's a great way to support me. The items were later found by the police, who also discovered the victim's body a few hours after her death. A ballistics specialist concluded that there was a 90% chance that a bullet discovered in the victim's body had been shot by the .22 after a hair found on one of the masks matched the victim's hair. The victim's body contained genetic material, and samples of it matched Pye's DNA. He claimed he hadn't seen the victim in at least 2 weeks when he spoke with the police later that day. 15-year-old Freeman, however, confessed and decided to testify for the state. On March 20th, Pye became the first person to be executed by the state of Georgia since January of 2020. The defense team for Pye contended that the trial counsel did not sufficiently probe Pye's life, background, physical, and psychiatric health in order to keep the jury from hearing mitigating evidence when Pye was sentenced. Evidence of poverty, abuse, and neglect throughout his early years was put forth by them. Additionally, they maintained that he had impairments to his capacity to plan ahead and regulate his impulses due to frontal lobe brain injury, which may have been brought on by fetal alcohol syndrome. A 3-judge panel of the 11th U.S. Circuit Court of Appeals sided with Pye's attorneys in April of 2021, despite the federal court rejecting those claims. However, the full federal appeals court reheard the case and reversed the panel decision on October of 2022. Adams received 5 life prison sentences to be served consecutively. At the Jackson State Prison, Willie James Pye, 59 years old, was given an injection of the sedative pentobarbital and was later declared dead at 11:03 p.m. When the warden asked Pye if he had any last words, he replied that he didn't. He said that he would like a prayer said for him when suggested. Following a brief prayer, a clergy member asked God to grant Pye some grace and kindness. The medicines started flowing while Pye was entirely motionless. About half a dozen times he started to exhale quickly, making his lips tremble and his cheeks dimple every time. He soon stopped moving. The warden entered the death chamber a few minutes later and declared the time of death. 2 chicken sandwiches, 2 cheeseburgers, French fries, 2 bags of plain potato chips, and 2 lemon-lime sodas are said to have been Pye's last meal order. Before his execution, he received 1 last visit from his attorney, 6 family members, and a member of the clergy. 30 years after her mother's essay and murder, Yarbrough's oldest daughter, Tawana Bell, the oldest of her 3 children, said she found closure in Pye's death. Yarbrough's cousin, Jernita Starks, also spoke to the media, expressing her disappointment that Pye's death sentence was the main media title and that the victim, who Yarbrough's family believed should be remembered, was not receiving the same attention as Pye. There were 2 people scheduled for execution in April, Michael Smith in Oklahoma and Brian Dorsey in Missouri. Michael Smith, Oklahoma, 22 years on death row. Michael Dewayne Smith was a part of the Oak Grove Bows, an Oklahoma City-based branch of the Crisp Gang. Teron T. Knock Armstrong and 2 other OGP members attempted to loot Trans Food Mart in South Oklahoma City in November 2000. Mr. Armstrong was slain by gunfire from the store owner. Even though Mr. Smith had deep personal ties to Mr. Armstrong, he was not a part of the heist. After being apprehended, the other two would-be thieves were scheduled to stand trial for the crime in February 2002. Smith entered Janet Moore's residence with a revolver 2 days prior to the trial. He broke down Mrs. Moore's door and confronted her, thinking her son was a police informant. Smith shot her dead when she started to scream. He cleaned the apartment to remove any traces of his fingerprints before leaving. He then walked to the AZ Mart, a convenience shop directly next door to Trans Food Mart. Sarat Puluru, the store's on-duty employee, was emptied 2 pistols into by Smith, who also stole money from the register and lit fires all around the store with lighter fluid. In order to destroy evidence, he set fire to Puluru's body and everything he had touched in the AZ Mart. He afterwards disposed of the clothing he had been wearing while committing the killings. He was apprehended, convicted, and sentenced to death. Smith was just 19 years old when those killings occurred. In November 2001, he was also wanted for his involvement in Otis Payne's shooting killing outside the Lexus Club in northeast Oklahoma City. After he admitted to giving the gun to the shooter, David Burns, he was given a life sentence for that offense. In March, the Oklahoma Pardon and Parole Board decided 4-1 against granting Smith clemency. He maintained his innocence during his clemency hearing, even though he had admitted to the killings just a few days after his arrest. Smith spoke to the board via video conference. Following a lethal injection, 41-year-old Michael Dewayne Smith was declared dead at the Oklahoma State Penitentiary at 10:20 a.m. According to witnesses in the media, when asked to make a last statement, he said, "Nah, I'm good." Smith was in the execution chamber with Jeff Hood, his spiritual counselor, who was reading from a Bible. Hood claimed to have informed Smith his family loved him prior to the execution. He also said that during the entire procedure, tears were streaming down Smith's right cheek. He claimed that after Smith was declared dead, the final tear fell. Smith made the odd choice to turn down the opportunity to place an order when he was given the option to choose what to have for his final meal. Rather, he consumed a few of the leftovers he received from the prison canteen. Smith was among the few death row convicts nationwide that had 3 or more murder convictions. Brian Dorsey, Missouri, 14 years on death row. Dorsey called his cousin Sarah Bonney on December 23, 2006, asking for a loan of money to pay 2 drug dealers who were in his apartment. Ben, Sarah's husband, called Darren Carroll, a friend, and asked for assistance in getting the people out of Dorsey's flat. Ben and Sarah took a car to Dorsey's residence. Following the 2 drug dealers being kicked out of the apartment, Dorsey went home with Sarah and Ben, where Carell and a few other people joined them. Sometime after Sarah and Ben went to bed, Dorsey went into the garage, got a single shotgun, and shot Sarah in the jaw, killing her at a distance of around 12 inches. After emptying the chamber, Dorsey loaded the rifle again, put it to Ben's right ear, and fired. Ben passed away on the spot. He also essayed his cousin's body and then covered her torso in bleach. Dorsey removed Sarah's social security card from a wallet and dispersed the contents next to her body. He stole several things she owned from the house. Driving in Sarah's car, Dorsey left the house and went to Jefferson City, where he met a woman he had borrowed money from to acquire drugs. Dorsey attempted to pay the woman with what was ultimately identified as Sarah and Ben's belongings. Sarah and Ben had not shown up for a family get-together, so Sarah's parents went to see how they were doing on Christmas Eve afternoon. When they entered, Jade, Sarah's 4-year-old daughter, was seated on the couch watching TV. Jade told her grandparents that she had been attempting all morning to wake up Sarah, but had been unsuccessful. Sarah's parents knocked on the bedroom door and yelled for her. There was no reply. Sarah's father had to pry open the locked door using force. On the bed, he noticed Ben and Sarah. Following the confirmation of Sarah and Ben's death, Sarah's father departed the house accompanied by Jade and Sarah's mother before calling the police. The subsequent inquiry verified that a single gunshot wound to the head caused the deaths of both Sarah and Ben. Furthermore, analysis showed that genetic material found in Sarah's body had DNA similar to Dorsey's and men from a same paternal lineage. Ben's potential involvement in the murder was thus ruled out. When Dorsey turned himself in to the police on December 26, he confessed that he was the right guy in regards to the couple's deaths. Dorsey faced 2 charges related to first-degree murder. He entered a guilty plea to both counts in March 2008. The trial court condemned Dorsey to death after the jury returned death sentences for each homicide after a separate penalty phase trial. The 52-year-old Dorsey was put to death a few hours after the U.S. Supreme Court declined to step in and roughly a day after Missouri's Republican governor refused to grant clemency, turning down the prisoner's request to have his sentence commuted to life in prison, which was supported by more than 70 correctional officers and other people as well. Dorsey apologized to the families of his victims and thanked those who had supported him in a final written statement. To all of the family and loved ones I share with Sarah, and to all of the surviving family and loved ones of Ben, I am totally, deeply, overwhelmingly sorry. Words cannot hold the just weight of my guilt and shame. I still love you. I never wanted to hurt anyone. I am sorry I hurt them and you. To my family, friends, and all of those that tried to prevent this, I love you. I am grateful for you, he said. I have peace in my heart in large part because of you, and I thank you. To all those on all sides of this sentence, I carry no ill will or anger, only acceptance and understanding. According to their statement, Sarah Bonney's family experienced severe anguish from the killings, with her parents finding the bodies. The family took annual balloon releases with their daughter at the cemetery as one of the ways they tried to preserve Sarah and Ben's memory in the years that followed. For his last meal, Dorsey had 2 bacon double cheeseburgers, 2 orders of chicken strips, 2 large orders of fries, and a Casey's pizza with sausage, pepperoni, onion, mushrooms, and extra cheese. Jamie R. Mills, Alabama, 16 years on death row. In 2004, Floyd and Vera Hill, a 55-year married couple, were robbed and brutally murdered. Jamie Ray Mills was convicted and sentenced to death for their murders, even though he denied any involvement in their deaths. On June 24, 2004, in the late afternoon, 30-year-old Jamie Mills and his spouse Joanne Mills went to Floyd and Vera Hill's residence on County Road 54 in Gwinn, Marion County, Alabama, with the intention of robbing them. Mrs. Hill, 72 years old, suffered from diabetes and was in terrible health. Mr. Floyd Hill, who was 87 years old, took care of his sick wife by giving her prescribed medications, which he stored on the kitchen table in a secured tackle box. He set his alarm for every 4 hours to make sure her prescription pills were given on time and correctly. The Hills lived alone, but their adult grandkids who lived nearby often came to see how their grandparents were doing. Even though they were both retired, the Hills often conducted yard sales, probably more to keep themselves busy and active than to supplement their Social Security income. The workers at the nearby Amoka fuel station, where Mills was last employed before the killings, knew Mr. Hill to usually pay for his gas with cash and to constantly carry substantial amounts of cash in his pocket. Mills denied knowing the Hills, but the jury came to the conclusion that he, who was unemployed at the time, was undoubtedly aware of the Hills and had planned a scheme to steal their money. On June 24, 2004, shortly after dusk, Angela Jones visited her grandparents, Floyd and Vera Hill, after multiple phone calls to inquire about their well-being had been unsuccessful. The Hills seemed to be at home, but when they knocked on the door, nobody answered. The door was locked. For a welfare check, Angela called the police department. It took Officer Larry Webb about 3 or 4 minutes to get to the house. When Webb got there, Angela Jones told him that the Hills had spoken to her family just after 2 p.m., and that was when everything was okay. The Hills did not answer when Officer Webb and Mrs. Jones knocked on the doors and windows. Webb picked up his cell and dialed the Hills residence. Although there was no audible ring coming from the Hills house, it was discovered that his cell phone was ringing. Then, from the front porch, Officer Webb pointed his flashlight inside the house, and Angela saw that Vera Hill's walker was in the living room and her bed was made and vacant. There was no movement in the house, despite Mr. Hill's alarm going off for Mrs. Hill's prescription. Mrs. Jones started to worry that there was a serious problem. Webb then went to the prefabricated building on the Hills' property, which was encased with polyethylene-type plastic and X-type lattice to store items from their yard sale. Webb dragged the little bench up to the door and climbed up to see over it because it was padlocked. At the back of the building, Officer Webb saw Floyd Hill lying on his back in a pool of blood with a bloody towel put over his face. Mr. Hill had his cane positioned across his lower limbs. Then, just inside the door, Webb noticed Vera Hill lying on her right side. Her face and head were covered with blood, and she sat in a puddle of it. Vera Hill made a left arm motion. Webb contacted 911 at 8:42 p.m. to request the dispatch for an ambulance and then asked for backup. After breaking through the plastic wall and tearing off the lattice, Webb entered the building and examined Vera Hill. She was still breathing. Floyd Hill was cold to the touch and had no pulse. Webb saw that Mrs. Hill had numerous long bleeding gashes on her head, and she said, "Let me out of here," several times when people asked her what had happened. After receiving medical attention, she was taken to the hospital via ambulance. Floyd Hill was declared deceased on the spot. The Gwynn Police Department, the Marion County District Attorney's Office, and the Alabama Department of Forensic Science jointly secured the area and launched an investigation. Vera Hill's clothing and fingernail clippings were obtained, the crime scene was analyzed, pictures were taken, and blood samples were gathered. As the victim's house and possessions were being processed, it was found that the Hill's phone line was disconnected, a police scanner was missing, as well as Floyd Hill's wallet, Vera Hill's purse, and a green padlocked tackle box containing Vera Hill's medication. Following Floyd Hill's autopsy, blunt and sharp force injuries to the head and neck were found to be the cause of death. 2.5 months after being moved from the Winfield Hospital to UAB Hospital in Birmingham, Alabama, where she received treatment for brain injuries, a depressed skull fracture on the back of her head, fractures around her left eye, fractures to the nasal cavity, a broken neck, and crushed hands, Vera Hill passed away on September 12, 2004, at the home of her daughter, Brenda Barger, while receiving hospice care. Vera Hill's autopsy revealed that complications from blunt head trauma were the cause of death in her case. During an interview with Jennifer Yaden, the Hill's next-door neighbor, at around 11:15 p.m. on June 24, 2004, Marion County District Attorney investigators Tommy Moore and Ken Mays learned that Yaden had observed a white, late-model four-door sedan passing by her home multiple times that day. She saw that identical car parked in the Hill's driveway as well. On June 25, 2004, at around 12:05 a.m., investigators Moore and Mays went back to the crime site and spoke with Officer Larry Webb and Chief Brian McCraw of the Gwynn Police about the information they had received from Yaden. Webb and McCraw both told the detectives about a man in the area called Jamie Mills who drove a white vehicle similar to the one Yaden had described. A patrol unit was dispatched to Jamie and his wife Joanne's home at this point, but it didn't seem like anyone was there. Chief McCraw was asked by investigator Moore to regularly send a car to the Millses' home to check whether they were home to be questioned. Officers Baylock and Webb discovered Jamie and Joanne trying to flee the Millses' home in a little white 1990 two-door Nissan Infiniti M30 at 9:45 a.m. on June 25. The Millses attempted to leave but were blocked by the officers pulling across the drive. Then, in order for them to speak, Officer Baylock requested Jamie Mills to back the car up in the drive. On June 24, 2004, Mills was taken to the Gwynn City Hall to be questioned over his whereabouts. At this point, he denied knowing anything about the Hills and claimed that on June 24, he and Joanne were in Brilliant house hunting before spending the night at his father's house. When Marion County District Attorney Jack Bostic and investigator Ted Smith came at the Millses' home, they questioned Joanne about her whereabouts at the day of the Hills assault. She consented to the search of the Millses' residence, their white two-door sedan, and the car's trunk while she was being questioned by investigator Ted Smith. A green tackle box that fit the description of the tackle box Vera Hill used to store her medication was visible in the car trunk. It also had a cut padlock. A big blue duffel bag that seemed like it had been smeared with blood was also clearly visible. Joanne was read her Miranda rights at this point, but she chose to waive them in order to make a statement. After that, a search warrant was issued and Officer Webb and Police Chief Brian McCraw were summoned to the residence. Officers from the Gwynn Police Department, the Marion County Drug Task Force, and the Alabama Bureau of Investigation carried out the search. Jamie Mills was brought back to his home during this period, where he was later arrested for capital murder and taken to the Marion County Jail. The search of the items contained in the vehicle's trunk revealed that the green tackle box contained numerous pill bottles with prescriptions belonging to Vera Hill. The duffel bag contained an assortment of items, including one large concrete block, one pair of size 12 tennis shoes with bloodstains on them, one bloodstained pair of work pants with Jamie Mills's name on the inside tab, one black t-shirt with bloodstains, one pair of tennis shoes with bloodstains, one telephone with cut cord attached, one man's wallet containing the driver license of James Floyd Hill, one lady's purse with papers identifying it as Vera Hill, one machete with blood and hair on it, one ball-peen hammer with blood on it wrapped in paper, and one lug nut tire tool. The items from inside the trunk were itemized and photographed before the car, toolbox, duffel bag, and contents were handed over to forensic science for examination. DNA analysis was later performed on the machete, hammer, tire tool, black t-shirt, and black pants. Test results revealed that the primary source of blood found on the machete matched that of Floyd Hill, and the secondary source matched that of Vera Hill. The blood found on the ball-peen hammer matched that of Vera Hill. The blood found on the tire tool was a mixture, with Vera Hill being the major contributor and Floyd Hill being the minor contributor. The blood on the black t-shirt matched that of Vera Hill. The blood on the pants, containing the tab with Jamie Mills's name, matched that of Floyd Hill. Joanne Mills testified on August 22, 2007, during Jamie Mills's trial, that on June 23, 2004, she and her husband had spent the entire night using methamphetamine at their home. They remained at their house until about 5 o'clock on Thursday, June 24, 2004, at which point they went to the Webster's Market grocery store to buy cigarettes. Once the cigarettes were bought, she and Jamie departed Webster's and made a stop in the parking lot of Fred's Cheap Shop to speak with Brandy West, Joanne's cousin. Jamie told Joanne that he was going to talk to a man regarding money and that she should just follow him once they left Fred's parking lot. When the Millses arrived at the Hills house at approximately 5:15 p.m., the Hills welcomed the Millses inside, where Jamie tried using the Hills' phone to make many calls while Joanne sat and spoke with the Hills. Joanne claimed that Mr. Hill addressed Jamie by name and was clearly familiar with him. Vera Hill wanted to show Joanne Mills some of their yard sale items that were kept in their shed after Jamie had finished using the phone, and the two spouses had chatted for a while. Because it was raining, Floyd Hill opened the door of the padlocked structure and let Vera Hill, Jamie Mills, and Joanne wait outside. Floyd Hill then came back and handed the umbrella to the women so they could continue towards the building. Floyd left the building and walked back inside to retrieve a light fixture. Following the Hills' display of their sale things to the Millses, Jamie Mills carried on the conversation with Floyd Hill in the shed, and the two women made their way back to the porch. Joanne Mills testified that she heard a loud noise and saw what looked to be Jamie Mills's silhouette through the plastic siding of the building. He appeared to be swinging something with both hands over his shoulder. Then, Joanne went back to the shed with Vera to find out what had happened. When they entered the shed, they saw Floyd Hill on the ground and watched Jamie Mills use a hammer to strike Vera Hill in the back of the head. He hit Mrs. Hill with the hammer once more when she tried to stand up. Joanne went on to say that she heard Jamie hitting Floyd and Vera repeatedly while standing in the building's corner with her eyes closed. She heard Jamie walking back and forth between the two victims, his feet scraping the earth. Following the ending of Jamie's striking sounds, he handed Joanne Mills a machete, a tire tool, and a hammer. Jamie also showed her how to cover Floyd Hill's head with a white towel to stop the gurgling sounds. Then Jamie came out of the shed with Joanne Mills. After they locked the door, the two returned to the Hills' residence. Before leaving the house and going back to their own on County Road 83, the couple searched the house and removed the padlocked tackle box, Vera's pocketbook, the phone, and the police scanner. When Jamie got to the Mills' house, he carried everything from the Hills' house into the kitchen. Joanne showered. After that, Jamie and Joanne looked over the things they had taken from the Hills' house: wallet, handbag, prescription in the green tackle box, and everything else. They put them in a bag with the machete, tire tool, and hammer. About $140 in cash was retrieved by the Millses from the Hills. After taking a shower, Jamie called Benji Ho, a local drug addict. Benji visited the Millses at their house and bought some painkillers. He then left the Millses' home, and Jamie and Joanne put the bag that contained the belongings from the Hills' home in the shed before spending the night and playing dominoes at Jamie's father's house in Hamilton, Alabama. When Jamie and Joanne Mills arrived home the following morning, June 25, 2004, they discovered that dogs had ripped open the bag holding the bloodied objects from the Hills' home. Joanne pulled out a big duffel bag, and the Millses packed the following items inside: a huge cement block, a hammer, a tire tool, a phone, a wallet, a handbag, and the clothes they had on when the attacks occurred. Then the couple put the green tackle box and the duffel bag in the trunk of their car. Officers Baylock and Stanley Webb stopped the two as they were leaving the house to dispose of the tackle box and duffel bag. The state of Alabama executed Jamie Ray Mills, 50 years old, by lethal injection. At 6:07 p.m., the observation room's front window had its drapes open. Mills had an IV line in each arm and was strapped to a gurney cruciform. The lines passed through a tiny, square-shaped opening in the dead chamber's back. His last words were, "I love my family. I love my brother and sister. I couldn't ask for anything more. I love y'all. Carry on." Through the enormous glass window, Mills seemed to be able to see his witnesses. He repeatedly gave them the thumbs up. His spiritual guide came over to the stretcher and seemed to join him in prayer. Mills gave his spiritual advisor a wink before turning back to face his family and giving them the thumbs up. While receiving a blessing from the spiritual counselor, he closed his eyes and seemed to pass out. The advisor went to the foot of the stretcher, reached down, and touched his left leg. Mills's name was called out and his awareness was checked by a guard at the head of the gurney, who raked a thumb across Mills's left eyelid. The guard then gave Mills's upper left arm and inside skin a pinch. It seemed that Mills was still breathing. His chest was twitching slightly and his abdomen fluttered as though he was breathing very shallowly. During Mills's execution, a number of witnesses started crying. He seemed to draw his last breath at 6:16 p.m. Officials at the prison said that he passed away at around 6:26 p.m. On Execution Row, Mills met with 6 visitors and relished a seafood feast during his last hours. His last meal included 3 large shrimp, 2 catfish fillet, 3 oysters, 3 onion rings, and 1 stuffed crab. In connection with the crime, Joanne Mills is currently serving a life sentence without the possibility of parole. There were 3 people executed in the month of June. David Hosier, Missouri. While Angela Gilpin, the victim, was married to Rodney Gilpin, Hosier had an affair with her. In August 2009, the victim and her husband reconciled and the affair ended. Hosier shot and killed the woman and her husband in September 2009 after breaking into their residence. When the victim was killed, her purse held 3 documents: an application for a protection order against Hosier, service information proving she was aware of Hosier's past criminal history and multiple gun possessions, and a third paper expressing her fear that Hosier would shoot her and her spouse. Hosier went to Oklahoma after the killings, where he was apprehended by local law enforcement. Investigators found 15 guns, multiple types of ammo, a crowbar, a makeshift police baton, latex gloves, a bulletproof vest, and a knife in Hosier's car. All of the weapons discovered within the car were loaded, with the exception of the Sten submachine gun, which was identified as the murder weapon. A notepad with a detailed description of the victim's car and its license plate was also discovered by the police. Hosier called and left multiple voicemail messages for a woman who knew both him and the victim in the hours before the killings. Hosier was charged in the Circuit Court of Cole County. He was found guilty by the jury of first-degree murder, armed criminal action, first-degree burglary, and unauthorized possession of a firearm by a felon. The state provided proof of statutory aggravating circumstances during the penalty phase. Hosier was found guilty of a battery in Indiana, where he struck his ex-girlfriend in the face while she was in handcuffs, resulting in a major assaultive conviction. Over the years, Hosier's defense lawyers have attempted to overturn the death penalty on the grounds that there was insufficient physical evidence to connect Hosier to the killings. At the crime scene, there were no fingerprints, no eyewitnesses, no confession, and no evidence of David's DNA or any personal belongings. Additionally, attorneys contended that Hosier's past assault conviction improperly influenced the jury and should not have been included as admissible evidence in the Gilpin trial. A 19-page clemency petition cites Hosier's case's mitigating circumstances as the pain he experienced as a child from the murder of his own father. When Hosier was 16 years old, his father, Glenn Hosier, an Indiana state trooper, was slain while performing his job. Hosier later served in the U.S. Navy and worked in Jefferson County as a firefighter and emergency medical technician. Governor Mike Parson denied Hosier's request for clemency. At 11 a.m., Hosier had his last meal. It included apple pie, Texas toast, steak, baked potato, milk, and orange juice. According to witnesses, his eyes were closed during his execution, and at approximately 6:01 p.m., he made his final movement. The Reverend Jeff Hood, Hosier's spiritual counselor, was there in the execution room and placed his hand on Hosier's shoulder. His last statement was, "Now I get to go to heaven. Don't cry for me, just join me when your time comes." Ramiro Gonzales, Texas. Gonzales admitted to the essay and killing of Bridget Townsend in Medina County, west of San Antonio, while he was serving a life sentence for the kidnapping and essay of Florence Teich in 2002. He also led authorities to Bridget Townsend's remains. Nearly 2 years had passed since she vanished. According to court documents, Gonzales abducted, essayed, and shot Townsend dead in 2001 while they were both 18 years old. This happened when she stopped him when he was attempting to steal cocaine from her boyfriend's house, who was also his drug supplier. Gonzales recently filed pleadings seeking to have his sentence reduced to life in prison. He claimed that he was never given a proper post-conviction review and that he was not eligible for the death penalty because a state expert had recanted his testimony that he would be a danger to others in the future, which is a requirement for the death penalty in Texas. A portion of his most recent legal issues stemmed from the alcohol his mother consumed during her pregnancy and the childhood essay he experienced. While on death row since 2006, Gonzales claimed in a clemency appeal that he had dedicated his life to Christianity and acted as a spiritual guide for others facing the death penalty. Gonzales asked for leniency, but the Texas Board of Pardons and Paroles overwhelmingly denied his request. Gonzales stated in his mercy petition that he regretted his acts and the effect the murder had on Townsend's family on a daily basis. In 2022, he asked for a reprieve in order to donate a kidney to a patient, but his request was rejected. After receiving a chemical injection at the state penitentiary in Huntsville for the January 2001 murder of Bridget Townsend, Ramiro Gonzales, 41 years old, was declared dead at 6:50 p.m. In his final remarks from the death chamber, Gonzales apologized several times to the victim's family. "I can't put into words the pain I have caused y'all, the hurt, what I took away that I cannot give back. I hope this apology is enough. I never stopped praying that you would forgive me and that one day I would have this opportunity to apologize. I owe all of you my life and I hope one day you will forgive me." He drew 7 breaths as the medicine kicked in, then started making noises similar to snores. Less than a minute later, everything had stopped moving. Being on Texas death row, he was not granted a special last meal request. Before talking about the last person executed in June, please hit that like button. Richard Norman Rojem Jr., Oklahoma. Layla Dawn Cummings, his former stepdaughter, was 7 years old when Richard Norman Rojem essayed, abducted, and killed her. Layla was taken from the apartment she shared with her mother, Mindy Cummings, and her brother, Jason Cummings, between 10 p.m. on July 6 and 1:15 a.m. on July 7. When Rick Quimby, who worked at a motel across the street, went to check on the kids, he discovered Layla was missing and informed Mindy at work. When Jason's mother left for work, he went to sleep, but when he heard a disturbance, he woke up. He said in court that he didn't hear any cries or struggle, but he did saw Rick. Jason told his father, Don Cummings, in court that he believed Layla was with Rick, but he did not see or hear anything. Don Cummings was Layla and Jason's father. On July 7, a farmer discovered Layla's body in a field. She was killed by neck stab wounds. She had also suffered a stab wound to the private area. Blood had drenched the ground 2 to 3 inches beneath her neck and chest, as well as the area around the private parts of her nightgown. The skin on her buttocks was torn and scratched with nails. Although she suffered blunt force injuries, no genetic material was discovered in her body. The majority of the information linking Rojem to the crime was circumstantial. He recently divorced Mindy because she discovered he was essaying Layla. He was trying to patch things up. He was aware of her work schedule and the malfunctioning apartment door lock. Near the flat, a plastic cup with his fingerprint on it was discovered. His beer had been put in a comparable cup and he had left the bar between 11:50 and 12:20. Rojem contacted his workplace at 1:14 a.m. and asked the dispatcher to record the call at 12:35 a.m. Later on, he asked that the call be recorded at the proper time. Police discovered a condom packet and a used condom containing genetic material when they investigated Rojem's room. The washer at the bar where Rojem had been featured a dispenser selling this generic brand of condoms. Just before leaving the bar, he had gone to the bathroom. The 2 rear tires and 1 front tire of Rojem's car were identified by tire track impressions close to the body. The other front tire's track impression did not match the one on Rojem's vehicle. However, the state provided proof that Rojem had changed that tire on July 7 in the morning. The other tires were 15-inch non-radials, whereas that one was a 14-inch radial. Rojem had requested that a co-worker inform the police that he and another employee had changed Rojem's tire following a blowout. "The police may have a tire they used to put me in jail," Rojem warned the co-worker, "and if you don't tell them you changed the tire, it'll be death punishment and 2 lives instead of 1. The co-worker refused to lie. According to a statement from the California Department of Corrections Director, Stephen Harp, the execution began at 10:03 a.m. Beside the death chamber, in a room, Rojem glanced at a few witnesses before the first medicine, the sedative midazolam, started to take effect. When Rojem was being executed, a spiritual counselor was there in the death chamber with him. At 10:08 a.m., Rojem was deemed unconscious. At 10:16 a.m., his death was confirmed. Rojem was served his last meal on Wednesday at 5:48 p.m., which included a small Little Caesars pizza with double cheese and double pepperoni, a ginger ale, and 2 vanilla ice cream cups. When asked if he had any last words, he said, "I don't. I have said my goodbyes." There was only one person executed in the month of July. Keith Edmund Gavin, Alabama, July 18. Gavin was found guilty of killing William Clinton Clayton Jr. in 1998 and robbing him in front of a Regions Bank in Center, Alabama. He already had another murder conviction for a killing that happened 20 years prior to this one that brought him the death penalty. Clayton, a contracted courier with Corporate Express delivery systems, was shot and killed on March 6, 1998, just after 6:30 p.m., when he was seated in a Corporate Express van outside the Regions Bank in downtown Center. After completing his deliveries for the day, Clayton made a stop at Regions Bank to use the ATM to get cash so he could take his wife out to dinner. Out of the 4 people who saw the incident, 2 were able to positively identify Gavin as the gunman. In their depositions, Ronald Baker and Richard Henry Jr. stated that they were at a stop sign close to the Regions Bank and the court building in downtown Center when the shooting occurred. Baker and Henry reported that they witnessed a man exit a car, cross to a parked van on the street, and shoot the van's driver. Baker and Henry heard the gunshots and left the site right away, but none of them was able to identify the shooter. Larry Twilley testified that he heard a loud noise as he was stopped at a light, turned and witnessed a man brandishing a revolver, open the driver's side door of a van that was parked on the street, shooting the van's driver twice. After forcing the driver to the passenger's side, the gunman took the wheel and started to drive off. Twilley stated in his testimony that he observed something red and black surrounding the gunman's head when he first saw him, but that after the gunman left in the van and removed whatever he had on his head, he seemed to have very little hair. Twilley positively identified Gavin as the shooter during the trial. In early February 1998, Dewayne Meeks, who worked for the Illinois Department of Corrections and is Gavin's cousin, told the court that he and Gavin left their home in Chicago, Illinois, and proceeded to Cherokee County, Alabama, to pick up some females and simply to get away. Meeks claimed that after spending a weekend there, they left and went back to Chicago. Gavin intended to go back to Alabama in early March 1998 in order to find the woman he had met in February. Meeks stated in his deposition that Gavin promised to pay Meeks's travel expenses if he drove Gavin to meet the woman in Chattanooga, Tennessee. Meeks stated that he consented to drive Gavin to Tennessee and that they were joined by Meeks's wife and son, who was 3 years old. In court, Meeks stated that they departed from Chicago on March 5, 1998, arrived in Chattanooga early on March 6, and lodged at a Super 8 motel. Meeks claimed to have reserved 2 rooms at the motel, one for Gavin and one for himself and his family. The 2 of them drove to a nearby gas station to wait for the woman. When the woman failed to appear, Gavin wanted to go to Fort Payne, Alabama, so he could locate her. Meeks consented, but they traveled to Center in an attempt to find the woman after they were unable to find her in Fort Payne either. Meeks stated in his deposition that he and Gavin arrived in downtown Center on March 6, 1998 at around 6:30 p.m. He claimed that once they came to a stop at a crossroads close to the Regions Bank and the courthouse, Gavin exited Meeks's car and went up to a nearby parked van. Meeks said that he believed Gavin was going to ask the van's driver for directions, but when Meeks looked up, he saw that Gavin was carrying a gun and the van's driver's side door was open. Meeks claimed to have witnessed Gavin shoot the van's driver twice. He said that as soon as he saw Gavin shoot the van's driver, he left the scene and Gavin got into the van and pursued him. Meeks stated in his deposition that Gavin tried to stop him by honking the van's horn and flashing the lights. Meeks was afraid and claimed that after telling his wife what had transpired, they went back to Chicago. He also said that he told several of his law enforcement friends about the incident as soon as he got to Chicago. He said that after speaking with his friends, he came to the conclusion that Gavin had most likely been carrying the firearm that the Illinois Department of Correction had given him. After checking his house, he discovered that his gun was actually missing. Meeks said that he did tell his boss at the Illinois Department of Corrections that he thought the weapon had been used in a shooting in Alabama, but he did not tell law enforcement when he reported the missing gun. Meeks was interrogated in Chicago on March 9, 1998, and then on April 6 by Alabama investigators. Following the interviews, he was charged with capital murder in relation to Clayton's death. However, the accusation was later dropped. The District Attorney's Office for the 9th Judicial Circuit's investigator, Danny Smith, testified that on March 6 he was driving back to Center from Fort Payne when he heard over the radio about a shooting. Investigator Smith stated that he observed a van that matched the description broadcasted over the radio and followed it as he moved toward Center. He said the driver was moving erratically and the vehicle was going around 75 miles per hour. According to his testimony, the van turned on its blinker and stopped on the side of the road while he was talking about stopping it over the radio with several law enforcement officials. Smith said the van suddenly turned back onto the road and took off when he approached it from behind. He pursued the van further and noticed that it stopped in the middle of the road close to the junction of Highway 68 and 48 after he switched on his emergency lights. According to investigator Smith's testimony, the driver of the van stopped, got out, shot at him, fled in front of the van, turned around and shot at him once again before running into some nearby woods. The van's driver was dressed in blue trousers, a toboggan or other form of cap, and a shirt that was either maroon or wine in color. During the trial, Smith was able to conclusively identify Gavin as the individual who had exited the van and fired shots at him. Once Gavin ran away into the woods, Smith went to the van and examined the victim. The victim was barely alive, according to him, and he radioed for an ambulance. There was very little blood on the driver's seat, but when he initially arrived at the van, he noticed blood on the passenger seat and between the two front bucket seats. According to Smith, the individuals who had to enter the vehicle in order to secure and extract the victim spilled blood on the driver's seat as the victim was taken out of it. Gavin escaped into the woods, and shortly after, a number of law enforcement personnel showed up at the crossroads of Highway 48 and 68. They immediately surrounded and shut off the wooded area, making it impossible for anyone to escape and cross the road without being noticed. Then, agents from multiple law enforcement organizations searched for Gavin. Tony Holliday, a dog handler at the Limestone Correctional Facility, showed up at the scene with his beagle at around 9:45 p.m. According to the information Holliday was given when he initially arrived, investigator Smith had pursued the suspect for about 20 yards before coming to a stop outside the trees. In order to prevent the dog from following investigator Smith's path from the road and instead follow the route of the person who had entered the woods, Holliday claimed to have had investigator Smith show him the precise location where he had ended the chase. In his testimony, Holliday said that he then carried his dog to that location and laid him down. The dog detected a scent right away and followed it into the forest, ending up at a creek. Holliday testified that he observed a man standing in the creek under a bush that he positively identified as Gavin, and that Gavin tried to run away from him when he noticed him. He gave Gavin the command to halt, but Gavin didn't comply until Holliday shot Gavin in the shoulder. After handcuffing Gavin, a number of law enforcement personnel helped to guide him through the woods, up the embankment and out of the creek to the road. Clayton was pronounced dead at the hospital. A subsequent autopsy revealed 3 gunshot wounds to his body caused by 2 bullets. One bullet passed through Clayton's left arm, entered his chest on the left side, damaging both of Clayton's lungs and his heart, and exited the right side of the chest. That bullet was later found lodged in the passenger side door of the van. The second bullet entered Clayton's left hip and lodged in his back. The wounds to Clayton's arm and hip did not bleed much because the bullets entered the muscles and the bleeding was contained inside those muscles. The wound to the chest bled quite a bit, and after blood filled the chest cavity, it exited the body at the lowest point. According to the record, neither bloodstains nor usable fingerprints were discovered on Gavin's clothing or in the van. Nonetheless, the state produced proof showing that, following Gavin's arrest, a motel room key, which fit room 113 at the Super 8 Motel in Chattanooga, where Meeks and Gavin had reserved accommodations, was discovered in his pants pocket. Furthermore, a red and black toboggan cap was discovered close to the woods by the intersection of highways 48 and 68. 2 .40 caliber shell casings were discovered in the streets outside the Regions Bank in downtown Center, and 1 .40 caliber shell casing was discovered in the roadway at the intersection of highways 48 and 68. It was also discovered that the bullet in Clayton's back and the bullet lodged in the van's passenger side door were both a .40 caliber. A Glock pistol was located close to the woods where Gavin had been found on March 13, 1998, despite the fact that law enforcement was unable to locate the murder weapon the night of the incident. Gavin was found guilty of murder in Cook County, Illinois in 1982. He was only recently freed on parole, having completed about 17 years of a 34-year sentence before Clayton's murder. At the William C. Holman Correctional Facility in Atmore, Gavin, 64 years old, was executed by lethal injection, making him the third prisoner executed by the state this year and the 10th in the country. Since 1998, Gavin has insisted on his innocence, placing the blame on his cousin, who was present when the crime was committed. There were no apparent difficulties when the execution started at 6:16 p.m., according to the witnesses. At 6:20 p.m., Gavin appeared to have passed away as he had closed his eyes. He didn't seem to respond physically to anything during the procedure. "I love my family," was Gavin's last statement before he passed away. He seemed to pronounce a few Arabic terms as well. He had converted to Islam during imprisonment. According to the Alabama Department of Corrections, Gavin skipped breakfast, lunch, and dinner the day before he was put to death, but he did consume a bag of Ruffles cheddar sour cream potato chips, a bag of Lay's plain potato chips, and a chocolate Hershey bar with almonds. According to the prison department, Gavin did not make any special requests and declined his last meal on Thursday. He did enjoy a snack of some ice cream and some Mountain Dew. On Thursday as well, Neil Conrad and Daniel Epstein, Gavin's attorneys, paid him a visit and were among those who saw him put to death. There was another inmate scheduled for execution in July, Ruben Gutierrez from Texas Death Row. The proceedings were canceled 20 minutes before starting because the Supreme Court decided to grant him permission for post-conviction DNA testing at the last minute. 3 people have been executed in the month of August. Arthur Lee Burton, Texas, August 7. In Houston, Texas, on July 29, 1997, Burton approached a white woman jogging through her neighborhood. He dragged her into a forested area nearby and tried to assay her. The victim started to scream when she heard the witness getting closer. Burton killed her by strangling her with her own shoelaces. That day, just after 7 p.m., Nancy Edelman left the house for a little jog along the bayou that was close to her residence. Sharon Leyland was watching her kids play by some large machinery by the bayou at about 7:20 p.m. She was astonished to turn around and see a man on a bicycle who appeared to be filthy and angry standing very near her. Leyland greeted him, but all the man did was shoot her a cold stare. The meeting made Leyland feel intimidated, so she called her kids and headed home. Leyland observed Edelman walking down the bayou as she was calling her kids. Afterwards, Leyland recognized the man riding the bicycle as Burton. The following morning, the police found Edelman's body in a 3 to 4 foot deep hole in a densely forested region off the jogging track by the bayou. The authorities assumed she had been assayed since her underwear had been taken off and thrown some distance from the body. Edelman's body seemed as though she had been severely battered. Nancy Edelman, who was the oldest of 3 children and originally from Baton Rouge, Louisiana, loved theater and poetry. Her daughter claims that her mother started writing poetry when she was 11 years old and published collections all through her life. Before relocating to Houston in the late 1970s, she earned a Master of Fine Arts from the University of Minnesota and a degree in drama from Louisiana State University. She soon married Mark Edelman, her spouse of 18 years, and the two went on to have 3 children. Burton originally denied ever riding his bicycle near the swamp and denied killing Edelman when Deputy Sheriff Benjamin Beal contacted him. After being presented with discrepancies in the evidence he had gathered, Burton eventually admitted to the crime. He acknowledged assaulting a jogger, pulling her into the woods and strangling her until she passed out in a written statement. He then undressed her and made an attempt at assaying her. He choked her once more and pulled her into a hole when she came to and started screaming. He went back and used her own shoelace to choke the jogger after spotting someone else strolling in the area. Together with the crime's details, the state produced proof that when Burton was 18 in 1988, he had taken part in 39 car and outbuilding break-ins in a single month. Along with his other co-defendants, he had stolen firearms, radios, fishing gear, calculators, and other stuff. Occasionally, the offenders would simply rummage through any papers in the car before destroying the inside. They would not steal anything. During his testimony, Burton's brother acknowledged that while Burton was a resident of Arkansas, he sold cocaine and used Mary Jane. According to Burton's attorneys, 2 experts' reports demonstrated that the man exhibited low scores on tests of learning, reasoning, comprehending complex ideas, problem-solving, and suggestibility, all of which are examples of significant limitations in intellectual functioning. They claimed that because of the compelling evidence of his intellectual handicap, he was categorically exempt from the death penalty. The prosecution, however, maintained that Burton had not previously asserted any intellectual handicap and had only done so 8 days prior to his planned execution. Burton's appeal for a stay of execution was denied by lower courts, and hours before the injection time, the U.S. Supreme Court denied his defense motion to intercede. Burton was the 11th prisoner executed in the United States and the 3rd inmate executed in Texas this year. On August 7 at 6:47 p.m. local time, Arthur Lee Burton, 54 years old, was declared dead following a fatal injection at the state penitentiary in Huntsville. Burton's final statement was the following: "I want to say thank you to all of the people who support me and pray for me. For those of you I know and do not know, thank you for your support and prayers. 2727 and a full circle to all of the guys at the Polonsky unit. I love you guys. Bird is going home. To all the people I have hurt and caused pain, I wish we didn't have to be here at this moment, but I want you to know that I am sorry for putting you all through this and my family. I'm not better than anyone. I hope that I find peace and y'all can too. Warden, I'm good." Since Texas no longer grants special meal requests, Burton was offered whatever was on the menu that day for all the prisoners. Taberon Dave Honie, Utah, August 8. The U.S. state of Utah executed Honie for the 1998 murder and essay of Claudia Ben, the mother of his ex-girlfriend. Since Ronnie Lee Gardner was put to death in June 2010, he was the first person to receive the lethal injection in Utah in more than 14 years. Honie was a member of the Hopi tribe of Native Americans. He claimed to have gotten his first taste of alcohol at the age of 5. His lawyers claimed in a subsequent appeal that he was poor as a child and had severe brain injuries. Claudia Marie Ben, 49, was a member of the Paiute Indian tribe in Utah and the murder victim. She was regarded as a cornerstone of her community by her family. Along with taking care of her family, she worked as a substance abuse counselor. Carol Pickavit, with whom Honie had a relationship from about 1995 to 1998, was one of her daughters. The two had the daughter together. Pickavit moved in with her mother after splitting up with Honie. On the evening of July 9, 1998, Honie called Pickavit and demanded that she come see him right away. If she disobeyed, he threatened to kill multiple members of her family. Pickavit wasn't home when the murder occurred since she had left for work. A few hours later, Honie burst through a sliding glass door to gain entry into the Cedar City, Utah home Pickavit shared with her mother, Claudia Marie Ben. Ben tried using a kitchen knife as self-defense. Honie overpowered her and used the knife to strike her, severing her throat 4 times, deep enough to scar her backbone. Police arrived at Ben's home early the following morning in response to a 911 call from one of her neighbors. They discovered a shattered window and Ben's partially nude and disfigured body with deep stab wounds to her private parts. After discovering Honie in Ben's garage and seeing blood smears on his fingerprints, they took him into custody. Honie admitted to stabbing her when he was being arrested. Ben's 3 little granddaughters were found smeared in blood in the same house by the responding officers. Soon after Ben's death, Honie had essayed one of the kids. He mentioned his childhood poverty and maltreatment in a petition for clemency he filed on June 18, 2024. It was announced on June 24 that Honie's legal representative had submitted many petitioning papers to stay his execution. Honie appeared before Utah's parole board 2 days prior to his execution in order to ask for a reprieve. During the hearing, Honie admitted to being a monster and expressed regret for killing Ben. "The one thing that has sustained me over the years is my certainty that this would never occur if I were in a sound mental state. I don't offer any justifications." The parole board turned down Honie's plea. His last meal was a cheeseburger, French fries, and a milkshake. Honie's execution took place at midnight on August 8, 2024. In his last statement, he said, "From the start, it's been, if it needs to be done for the victims' families to heal, let's do this. If they tell you you can't change, don't listen to them. To all my brothers and sisters here, continue to change. I love you all. Take care." A dose of pentobarbital was administered at 12:04 a.m., and officials administered a second dose at 12:13 a.m. He flatlined at 12:21 a.m., at which point his family members were allowed to enter the execution chamber and perform a spiritual ceremony over his body. A medical examiner officially pronounced him dead at 12:25 a.m. Loran Kenstley Cole, Florida, August 29. On February 18, 1994, Cole was found guilty of murdering John Edwards and given the death penalty. John Edwards and his sister Pam went camping in the Ocala National Forest over the course of the weekend on Friday, February 18, 1994. Loran Cole came by and introduced himself as Kevin and helped them settle in as they were setting up camp in the Hopkins Prairie. Later that evening, Cole and William Pole, who was not related to Cole, returned to the Edwards' campsite. Cole introduced William Pole as his brother. The four made the choice to go for a walk after spending time by the campfire. Cole attacked Pam while she was on the move, knocking her to the ground, striking her in the head, and handcuffing her. John and Paul started to argue at the same time. Paul was holding a walking stick when John grabbed it and started beating him with it. Cole helped Paul in restraining John and placed him close to his sister on the ground while handcuffing Pam. All John could do was apologize to his sister for putting her in such a risky predicament while Cole and Paul were robbing the siblings. Paul moved Pam up the trail and Cole stayed behind with John and trashed him for earlier assaulting his brother with a walking stick. Cole soon joined Paul and Pam and advised them to wait until John fell asleep before leaving. After that, Cole returned to the injured John and cut off his throat while claiming to Pam that he was merely removing John from the trail and tying him up. John died from several skull fractures and a sliced throat. He was just 18 years old. Pam was returned to the campsite by Cole and Paul, where Cole essayed her. The following day, Cole assured Pam that John was fine while making the pretense that he was going to check on him. Pam was then assaulted again by Cole, who then tied her between two trees. Early on Sunday morning, Pam was able to free herself from the bonds. She initially stayed put out of concern for her brother's safety, but she ultimately hailed down a driver who drove her to call the police. Pam gave police a comprehensive description of Cole and Paul, which allowed officers to recognize them and apprehend them. William Pole was sentenced to life on all charges. Cole, 57, was executed by lethal injection on August 29 and pronounced dead at 6:15 p.m. at the Florida State Prison in Rayford. Cole was asked if he had any final words while being strapped to a gurney with leather bindings and a paper sheet covering his neck. Cole said, "No, sir," while gazing up at the ceiling. He looked back at those in the gallery who had gathered to watch his last minutes, nodded slightly, and then laid back down. At 6:03 p.m., Cole received the first of 3 injections. Following his sedation, he was rendered immobile by a second medication, and his heart was stopped by a third and final injection. After taking a few deep, difficult breaths, Cole's body jolted and trembled before becoming motionless. A guard shook Cole's shoulders firmly and patted his eyelids, calling him. He was lying with his mouth hanging open and his eyes closed. He passed away in 12 minutes. Cole's last meal was pizza, M&Ms, ice cream, and a soda. Timothy and Victoria Edwards, his victim's parents, said the following: "Mr. Cole has been granted 30 years of life in Florida State Prison. During those 30 years, he has been free to read books, study, eat proper meals, sleep in a bed, get medical care, bathe and exercise, receive visitors, and to simply exist. This is something he brutally took from our son, life. That cannot be undone. While we empathize with the victims' families, we often tend to forget that the inmates also have family members, and for them too, it's a tragedy to go through this. Cole had a 36-year-old son, Ryan, who felt like his father's punishment and execution were a nightmare. This is what he had to say. "Saying goodbye to my dad was the hardest thing I've ever done. I am being punished for something that I believe now is something my dad didn't even do. They want somebody to blame in order to give somebody else peace, but they are taking peace from somebody else." For a long time, Cole said he was not the one that committed the murder and that his friend was actually the one that did it. There were 5 people executed in the month of September. Freddy Owens, South Carolina, September 20th. Owens was convicted of murdering a store clerk during a robbery in 1997, and his execution was very controversial because of a last-minute information that could have exonerated him. Well, for that murder at least. Let's go through the details of what happened. Freddy Eugene Owens was born on March 18, 1978 in South Carolina. His mother, who was 18 at the time of his birth, placed him in foster care when he was 5 years old, and it is said that his family mistreated and neglected him. After his birth father, who had abused his wife and children, left their lives, he eventually returned to his biological mother, who had married another man in the meantime. But when Owens was 7 years old, he saw his grandma shoot someone, and his stepfather had abused his mother as well as him. Because of his background, Owens was diagnosed with antisocial personality disorder at a young age. Owens and his friends Lester Young, Nakio Vance, Stephen Andra Golden walked outside together on November 1, 1997, with the goal of committing armed robbery. Golden and Owens stormed inside a convenience shop holding the female cashier at gunpoint, while Young and Vance were somewhere else. During Owens's murder trial, Golden claimed that Irene Granger Graves, the 41-year-old clerk, was shot in the head by Owens after she failed to open the safe. After taking $37 from the cash register, Golden and Owens left the scene. They subsequently met up with Vance and Young, who were informed that Owens had shot a woman during the attempted robbery. Following their arrest on November 11, 1997, Owens and Golden, then 18 years old, were both charged with murder. Golden and the prosecution worked out a plea deal whereby the prosecution agreed to drop the murder case and the death penalty. Golden received a 28-year prison sentence after being convicted of voluntary manslaughter. Vance and Young were also charged in relation to the offense. Owens was put on trial by a jury on February 8, 1999, on accusations of murder, armed robbery, unlawful use of a firearm, and conspiracy to commit armed robbery. Even when Golden's evidence proved that Owens killed Graves personally during the heist, Owens insisted he didn't kill anyone and denied any involvement. Subsequent reports stated that the CCTV showed 2 men, Golden and Owens, entering the store while wearing different masks. One of them, Owens, wore a ski mask and shot and killed Graves. Owens was identified as the man in the ski mask, while Golden was the man in the stalking mask. The jury returned a guilty verdict on February 15, 1999, and Owens' sentencing trial was set for 2 days later. On February 16, 1999, less than 12 hours after his conviction for Irene Graves' murder, Freddy Owens killed a fellow inmate. Christopher Brian Lee, 28, was the victim. He was incarcerated for 90 days after committing a driving infraction. The day following Lee's murder, on February 17, 1999, Owens appeared in court for his sentencing hearing. There, he gave a thorough confession and described how he killed Lee in the cell he shared with Lee and 10 other prisoners. Lee is said to have made fun of Owens' conviction and even boasted to him that his cousin was a part of the jury that convicted him. This infuriated Owens, who attacked Lee. He hit him in the face, stabbed his throat and eye with a ballpoint pen, and brutally strangled him with a sheet. To put an end to the attack, Owens hit Lee in the head, burned his eyes and hair with a cigarette lighter, then choked him by forcing his left nostril shut and jamming a pen inside his right. As a result, Lee passed away, and Owens, who insisted on his innocence, said he did so because he had been wrongfully convicted. Lee's grieving family demanded an official investigation into Lee's passing. The prosecution argued that whatever sympathetic circumstances of Owens' background were, there was no excuse for his abhorrent actions and murderous behavior, and that he should take full responsibility for what he did. The prosecution brought attention to the tragic consequences of Graves's death, including the fact that her 3 children had to be sent away under the care of their grandmother. The defense had pleaded with the jury to show mercy because of Owens's chaotic childhood and mental illness. Owens received the capital punishment as a result. Following his sentencing for the death of Graves, Owens and Fred Walker Jr., a 19-year-old who was suspected of being Owens's accomplice in the prison murder, were both charged with Lee's murder. Around the time Owens used up all of his appeals against the death penalty in 2019, the second murder accusation against him was dropped. Due to procedural flaws in his first sentencing trial, on September 4, 2001, Owens challenged his conviction and sentence to the South Carolina Supreme Court. He was given the opportunity to have a new sentencing trial. On February 17, 2003, Owens received a second death sentence. A year after the death penalty was reinstated in his case, on November 20, 2004, Owens was given permission for another resentencing hearing. Owens received the death sentence for the third time. He attempted to have this third death sentence overturned as well, but on July 14, 2008, the South Carolina Supreme Court denied his appeal and upheld the conviction. In 2015, Owens converted to Islam and he went by the Muslim name Khalil Divine Black Son Allah. Owens was originally scheduled to be executed on October 3, 2008, but the U.S. Supreme Court granted a stay of execution while an appeal was ongoing, so the execution was postponed. Owens' execution was later rescheduled for January 9, 2009, but it was postponed again due to legal issues. 12 years later, a third death warrant was approved, rescheduling Owens' execution for June 25, 2021. However, this too was ultimately stopped by Owens' last-minute appeal, and the South Carolina Supreme Court decided that both Owens and Brad Sigmund's executions ought to be delayed until they were offered the option of dying by firing squad or electrocution. At the time of Owens' third death warrant, South Carolina had been operating under an unofficial moratorium on executions since 2011. This was because the state was experiencing a shortage of the drugs needed for lethal injection executions, as well as drug companies refusing to sell their products to the state so that executions could take place. Henry McMaster, the state governor of South Carolina, issued new laws in 2021 reviving the electric chair and introducing the firing squad as a backup technique in case lethal injection was not available. The legislation also gave prisoners the options to select the manner of execution of their choice. It was reported in September 2023 that the state had succeeded in acquiring medications to resume the use of lethal injections for executions. Less than a month after the Supreme Court's decision, on August 23, 2024, Owens' death warrant was issued, and on September 20, 2024, his execution was scheduled to take place. Owens was the first person in South Carolina to be killed in 13 years. He was given until September 6, 2024 to indicate his preference among the 3 execution procedures for carrying out his death sentence. As a Muslim, Owens refused to take part in making a decision that would result in his demise. Therefore, he sought to provide one of his attorneys the authority to make decisions on his behalf. Owens' attorney attested to the fact that she chose a fatal injection for her client. On September 18, 2024, 2 days before Owens was set to be executed, his attorneys filed an emergency motion based on a statement from his accomplice, Stephen Golden. In it, Golden claimed that Owens was not the real killer and that he had been wrongfully accused of being the shooter. He did not dare name the real killer for fear of being killed himself by the man and his associates, but he didn't want an innocent man to be executed. The South Carolina Supreme Court dismissed the claims of innocence because Owens had admitted to shooting and killing Irene Graves on multiple occasions, and he had testified about the crime in both his 1999 murder trial and his 2003 resentencing trial. Owens begged McMaster for clemency on September 18, 2024, pleading with the governor to commute his death sentence, but his clemency request was denied. At Broad River Correctional Institution, 46-year-old Owens was executed by lethal injection on September 20, 2024. He refused to say anything more than "bye" to his lawyer as his final words. Owens received a single pentobarbital dose at roughly 6:45 p.m. and was declared deceased at 6:55 p.m. For his final meal, he placed an order for 2 cheeseburgers, French fries, a well-done ribeye steak, 6 chicken wings, 2 strawberry sodas, and a slice of apple pie. In the month of September, 4 other people were executed, and there is a strong possibility that the next person we are going to talk about was in fact innocent and wrongfully convicted. Marcelus Williams, Missouri, September 24. Williams was accused of killing Felicia Ann Gale on August 11, 1998, during a break-in at her gated community in University City, Missouri. The St. Louis Post-Dispatch reporter Gale, 42, was discovered dead in her house after being stabbed 43 times with a butcher's knife that was taken from her kitchen. Williams was born on December 30, 1968, in South Bend, Indiana. When he was approximately 5 years old, his mother and 2 brothers relocated to St. Louis, Missouri. Williams was raised in a poor, dysfunctional environment where he was introduced to drugs, alcohol, and firearms at an early age. He also experienced essay at the hands of family members. He was abandoned by his parents and was given encouragement for his drug and alcohol addiction. Williams was greatly affected by the loss of his older brother in 1997, so much so that he broke into a home and was imprisoned till being found guilty in 1998 of robbing a donut shop. Williams had previously married a single mother with a daughter and had a son. He committed himself to studying Islam while he was behind bars. On February 5, 1956, Felicia Ann Gale was born and raised in Rockford, Illinois. After earning a journalism degree from the University of Illinois, she began her career as a reporter for the St. Louis Post-Dispatch, where she remained until 1992. She quit her job at the newspaper to focus on voluntary work and philanthropy, which included teaching and mentoring underprivileged kids. She married Dr. Daniel Pickus in 1979. Dr. Pickus oversaw the Interventional Radiology Division at Barnes Jewish Hospital in St. Louis. On August 11, 1998, Gale's husband came home in the evening and found her body. When police got there at about 8 o'clock at night, they discovered Gale covered in blood on her left side and in a fetal position. There were up to 43 stab wounds on her, and a big butcher's knife was discovered stuck in her neck. Authorities further said that she had defensive wounds to her hands and arms, including a sizable cut in her right elbow. She also had knife wounds to her back, thigh, and 2 more in her neck. Her husband's Macintosh computer, her jacket, and her purse were stolen. In the initial police report, investigators mentioned that the incident occurred during a neighborhood burglary spree. Gale's family offered a $10,000 reward in May 1999 for information that resulted in an arrest and conviction in the case. 2 people, Laura Asaro and Henry Cole, accused Marcellus Scott Williams of the crime. For his evidence, Cole was awarded $5,000, while Asaro made no request for compensation for coming forward. Williams's criminal history was considerable. Cole claimed that when both of them were being held on unrelated charges to the murder, Williams had confessed to him in a jailhouse. Williams was already serving the 20-year term he was given for robbing a donut business. Williams's girlfriend at the time of the incident, Laura Asaro, testified that Williams had confessed to her and described the events in detail. Asaro stated in her deposition that she discovered Gale's ID in a purse in Williams's vehicle. She further stated in her testimony that she observed blood on Williams's clothes, scratches on his neck, and a laptop in his vehicle. She is claimed to have revealed information not included in the public accounts of the crime. The physical evidence recovered from the crime site, including a shoe print, fingerprints, and hair found there, was deemed by prosecutors as inconclusive. These items did not match Williams. Although the murderer was wearing gloves, the knife found at the scene only matched the DNA of the prosecution team members who handled it after it was forensically examined and shown to be devoid of fingerprints. A St. Louis Post-Dispatch ruler and calculator that had belonged to Gale were found in Williams's vehicle after a search. Additionally, a man testified that Williams had sold the victim's laptop to him, and that laptop was a match to the one that was stolen from the crime scene. Williams was given the death penalty after being found guilty of first-degree murder in 2001. Following his trial, Williams was kept on death row at the Potosi Correctional Center. Up until August 2024, when he accepted an Alford plea of guilty, he insisted on his innocence in the Gale case. He made multiple unsuccessful appeals of his case. In 2015, his execution via lethal injection was initially planned. During the appeals process, the defense presented information showing that the DNA extracted from the knife at the scene did not fit Williams's profile and instead revealed an unknown guy. Later, that guy was identified as the male prosecutor who had handled the knife. Williams' execution was delayed until August 22, 2017. The state Supreme Court refused to hear the fresh DNA evidence or to halt the execution, thus questions remained. The prosecutor stated that despite the DNA evidence, they were confident in the case because it was not the foundation for the conviction. That day, Governor Eric Greitens ordered an impromptu stay of execution. In order to look into the fresh DNA evidence and other aspects of the case, the governor established a board of inquiry. When Mike Parson, the newly appointed governor, took office in June 2023, he dissolved the 5-judge panel without waiting for their report and lifted the stay of Williams's execution, arguing that the court had to reach a conclusion. Afterwards, State Attorney General Andrew Bailey requested that Williams's execution date be determined by the state Supreme Court. According to a lawsuit filed by the Midwest Innocence Project in August 2023, the St. Louis County prosecuting attorney has said on record that he has strong evidence supporting Williams's innocence. According to the Innocence Project, there is a history of the Missouri Attorney General's office rejecting DNA evidence that clears an accused individual. Wesley Bell, the prosecutor for St. Louis County, filed a motion on January 26, 2024, requesting the St. Louis County Circuit Court to set aside Marcelus Williams' death sentence. He pointed to obvious bias in the jury selection process, probable ineffective assistance of counsel, and possible flaws in the police investigation. He requested a hearing from the court to go over the new evidence as well as other details of the investigation and trial. A special prosecutor's assessment of the case and the conclusions of 3 separate independent DNA experts, all of whom agreed that Williams's male DNA was not on the murder weapon, comprised the new evidence. That DNA belonged to an associate prosecutor and investigator who had handled the murder weapon barehanded during forensic testing. August 21, 2024 had been scheduled for a hearing to establish his innocence. Nevertheless, the move to vacate was denied since Williams's conviction was not based in part on DNA evidence. His execution was set for September 24, 2024 once more. The St. Louis County Circuit Court in Missouri set a hearing for July 2nd to consider the evidence of Williams's innocence. Despite the ongoing fight to overturn his conviction, the Missouri Supreme Court decided on July 12, 2024, that his execution was to proceed. Williams agreed to a plea deal made by the prosecution on August 21, 2024, which changed his death sentence to life in prison without the possibility of parole. During the hearing, Williams's prosecutors made a strong case for him, pointing out that the murder weapon's DNA did not belong to him and that they had taken this into account when they offered him an Alford plea deal to avoid the death penalty. Andrew Bailey, the state attorney general, was against this choice and demanded that the execution proceed according to plan. That same day, the Missouri Supreme Court struck down the plea deal agreement, keeping September 24 as Williams's execution date. His claims of innocence were to be considered in a clemency hearing. A few hours before Williams's planned execution, Parson refused to grant him clemency, and the issue was taken up by the U.S. Supreme Court. They also denied the request to halt the execution. Williams, 55, was put to death by lethal injection on September 24, 2024 at 6 p.m. at the Eastern Reception Diagnostic and Correctional Center in Bonne Terre, Missouri, in spite of public pleas for mercy. Williams was given tater tots and chicken wings for his final meal. The office of Missouri Governor Mike Parson issued a statement defending Williams's execution, pointing to his past criminal history and his claimed prison activities, which included attacking other inmates and threatening correctional officers, among other things. As he passed away on September 24, Williams left behind the words, "All praise be to Allah in every situation." I've seen so many videos on other social media platforms from people that seem to be convinced this man was innocent. I have to say it's very rare to see prosecutors take the side of the accused and fight for his life, so that's one strong point I can't ignore. But the other evidence, the confessions from two other people, including his own girlfriend, the objects that belonged to the victim found in his possession, I don't know, I feel like there was not enough evidence to really support his innocence. Let me know in the comments what are your thoughts on the situation. In the same day Williams was executed, there was another inmate who was put to death in Texas, and what he did to land on death row, well, he fully deserved the death penalty. Travis James Mullis, Texas, September 24. Following an argument with his girlfriend, Karen Koberger, on January 29, 2008, Travis James Mullis, then 21 years old, drove his car with his 3-month-old son Elijah in the back seat. Mullis essayed his own son after parking his car in Galveston. He smothered Elijah as he cried, then repeatedly stomped on his head, breaking his skull and causing his death. He then threw the body to the side of the road near Sewell Boulevard. Jesse and Esmeralda Zarro, a married couple who were looking for animals, later found Elijah's body. Mullis left Texas and was missing for 3 days after killing his son. An arrest warrant was filed for him. Mullis turned himself in to the Philadelphia police on February 1, 2008, and he admitted to the crime. After being extradited back to Texas, Mullis faced charges for his son's death. In February 2008, his girlfriend was detained in New York and accused of endangering the welfare of her kid by leaving Elijah in Mullis's care, even though she was aware of his mental health issues and that the man could possibly harm the child. A little bit of background on Mullis. He was born on September 20, 1986, and he lost his mother when he was just 10 months old. His father had left the family not long after Mullis was born. He lived in Maryland after being adopted by his uncle and aunt, Gary and Ann Mullis, who served as his foster parents. As a child, he was essayed by Gary Mullis for 3 years, up until the age of 6. Gary Mullis was found guilty of molestation and he was sentenced to prison. Mullis frequently had psychiatric therapy for a variety of psychological issues, including suicidal and homicidal behavior, after the age of 4. He said that every time he assaulted someone, he experienced symptoms including hearing voices and flashbacks of his past abuse. At the age of 13, he was discovered essaying his 80-year-old cousin, and he was committed to the Jefferson School in Maryland, a facility for mentally disturbed young people. Before being discharged at the age of 17, he attended the juvenile school for 4 years. Later, when he was 18, Mullis relocated to Texas and lived with his girlfriend, and they had their son Elijah James Mullis, born on October 29, 2007. Mullis had a history of abusing young children prior to his 2008 arrest for murder. He told the authorities that he was sorry for Elijah's death and admitted to killing the boy because of his son's unceasing crying fits. After an hour of deliberation on March 11, 2011, the jury returned a guilty verdict, finding Mullis guilty of killing his son. A number of the children Mullis had assaulted in the past were called as witnesses in his sentencing hearing. The prosecution sought the death penalty because of the aggravating circumstances of the crime, while the defense argued for life in prison without the possibility of parole and pleaded for Mullis to be granted mercy for his difficult upbringing. On March 21, 2011, Mullis received a death sentence. Mullis's death warrant was issued on May 23, 2024, and it called for his execution to happen on September 24, 4 days after he turned 38. Mullis did not seek mercy with the Texas Board of Pardons and Paroles or make an appeal to stay his execution in the last months before his scheduled date. Mullis was put to death at Huntsville Unit via lethal injection on September 24. In his final remarks, he expressed gratitude to prison staff and officials for changes made across the system that made rehabilitation possible. He also apologized to the mother of his son and her family, saying he regretted taking Elijah's life, but that he had no regrets about accepting death and giving up his fight against the death penalty. He received a single dosage of pentobarbital before being declared dead at 7:01 p.m. Mullis was the fourth prisoner executed in Texas in 2024. Just 2 days after his execution, Alabama had scheduled the very controversial second-ever nitrogen hypoxia execution. Alan Eugene Miller, Alabama, September 26. He shot 2 co-workers dead in their office, then murdered a third person at a business he had previously worked for. He was apprehended shortly after the shootings when authorities forced him to stop after seeing him on the nearby Interstate 65. He got into a quick fight with the police. In the shooting murders of co-workers Lee Holdbrooks, 32, and Scott Yancey, 28, at Ferguson Enterprise, as well as Terry Jarvis, 39, at Post Airgas, Miller pled not guilty due to mental illness or defect. Miller drove a truck for Ferguson and, up until January, he worked for Post Airgas. Jarvis was a Post Airgas supervisor. Holdbrooks and Yancey worked for Ferguson. Miller was fired from Post Airgas in January and was driving a Ferguson truck at the time of the incident. According to a body of Holdbrooks, Miller was upset because he believed another driver, Holdbrooks, was getting longer and better routes than he was. According to reports, Miller had a history of altercation with co-workers and had once been dismissed for fighting at work. The Birmingham News reports that Miller frequently engaged in yelling matches with one of the 3 individuals he killed on August 5th based on interviews with his former co-workers and bosses. Miller was also a dedicated worker who kept to himself, according to his former co-workers as well. He was supposed to be put to death by lethal injection on September 22, 2022, but the execution was postponed because prison personnel could not set up an intravenous access to administer the lethal dose. This was considered a botched execution. It was determined that they would not be able to finish the execution before the deadline of midnight. After the attempt failed, Miller filed a federal lawsuit for how much he suffered mentally and physically during the attempt. The state of Alabama decided in November 2022 to use nitrogen gas instead of a lethal injection to put Miller to death. On September 26, Miller was put to death via nitrogen hypoxia at the Holman Correctional Facility in Atmore, Alabama. At 6:12 p.m., the viewing room's curtains opened and the prison warden read aloud his death sentence. In response to a question about his final words, Miller stated, "I didn't do anything to be in here." He made an inaudible request to his relatives and friends who were watching the execution to take care of someone, but it is not clear who that someone is. He repeated, "I didn't do anything to be on death row," and then said, "Thank you." After Miller said his last words, a corrections officer inside the execution chamber made sure the gas mask worn over his face was sealed tightly and closed the mask valve, which had been opened to allow Miller to speak. At 6:16 p.m., the gas seemed to begin pouring into the mask. His spiritual counselor approached him, touched his leg while praying, as Miller moved his fingers a little on the gurney. At 6:18 p.m., Miller then inhaled deeply and repeatedly raised his head off the gurney. He shook and trembled for approximately 2 minutes as he battled against the restraints on the gurney. Miller then gasped periodically for about 6 minutes. The curtains closed at 6:32 p.m., and he was officially declared dead at 6:38 p.m. Though shorter and less severe, the shaking resembled that of Kenneth Smith's death, the first nitrogen gas execution ever carried out. For his final meal, he got French fries, a baked potato, and a hamburger steak. With Kenneth Eugene Smith's execution in January 2024, this was the second time Alabama had used nitrogen hypoxia to execute a convicted prisoner. Miller's execution was the 1600th death penalty carried out in the U.S. since the practice resumed in 1976. In the same day Miller was put to death, Oklahoma had an execution scheduled as well. Emmanuel Antonio Littlejohn, Oklahoma, September 26. Convenience store owner Kenneth Mears, 31, was shot and killed on June 19, 1992 in Oklahoma City during a robbery carried out by 2 attackers. Glenn Bethany and Emmanuel Littlejohn, the perpetrators, were taken into custody and accused of killing and robbing Mears. In separate trials between 1993 and 1994, Littlejohn was given a death sentence and Bethany a life term. One contentious aspect of the case involved the absence of concrete proof as to Mears's killer. Throughout his appeals, Littlejohn insisted on his innocence, but the courts dismissed his arguments. Littlejohn, who had a lengthy criminal history, had just been released from jail for assault, robbery, and burglary at the time of the murder, and Bethany was a drug dealer. The two men agreed to carry out an armed robbery in order to collect cash since they were both in debt to a known drug dealer. Littlejohn and Bethany stormed into the business with guns drawn. One of the men shot Mears in the face during the armed hold-up. Then the two men left the shop. A number of individuals, including spectators outside the store and two of Mears's co-workers, witnessed the event. Born in Indiana, Mears was raised by his mother and had 3 brothers and 2 sisters who were deeply impacted by his death. Emmanuel Littlejohn spent over 30 years appealing his death sentence. In each appeal, Littlejohn maintained his innocence and said he had never shot Kenneth Mears. On August 7, 2024, Littlejohn appeared before the Oklahoma Pardon and Parole Board for his clemency hearing. He acknowledged his role in the robbery of Mears's convenience store during the hearing, but he said that Bethany was the one who pulled the trigger and that he did not kill Mears. Littlejohn apologized for his involvement in Mears's death, begged for pardon, and conveyed his condolences to Mears's family for their loss. Furthermore, Littlejohn's mother, who was just 15 years old when she gave birth to him, begged for forgiveness for her only child, whose death penalty drove her to give up drugs, a habit she had battled from her teenage years and during her pregnancy. The State Pardon Board recommended clemency for Littlejohn on the same day of the hearing by a majority vote of 3-2. Littlejohn's destiny was in the hands of Oklahoma State Governor Kevin Stitt. Stitt had only once awarded clemency in his time as a governor to convicted murderer Julius Jones. Littlejohn was not pardoned by him. Emmanuel Littlejohn, 52, was executed by lethal injection at Oklahoma State Penitentiary early on September 26. He was allegedly given a deadly injection with 3 drugs, potassium chloride, decuronium bromide, and midazolam. At 10:17 a.m., he was declared dead. Littlejohn is said to have turned to face his mother and daughter and stated, "Everything is going to be okay. I love you." Littlejohn's last meal request prior to his execution included a meat pizza, 2 slices of cheesecake, and Coca-Cola. October's death row cases reveal dark secrets. Let's dive into what sealed their fate, their haunting last words, and the meals they chose for their last moments. Garcia Glen White, Texas, October 1st. The 1989 triple murder of a lady and her 2 teenage daughters in Houston, Texas, led to his conviction and death sentence. He is also the main suspect in 2 other killings for which he was never prosecuted. One of 7 siblings, White was born in Houston, Texas on February 4, 1963. Known for his passion for football, he attended Wheatley High School before continuing his education at Lubbock Christian University. White's career was cut short by a knee injury, forcing him to leave school and take on low-paying occupations as a sandblaster, house painter, and fry cook. His girlfriend was also pregnant, and this contributed to his decision to leave school and work to support his baby. In time, White had another 2 children, but a new injury cost him his job. That's when he became addicted to drugs, which made him more aggressive. White got into a fight with Greta Williams, a 27-year-old sex worker, at a crack house in Houston in the fall of 1989. White was not involved in this crime at the time, but Williams was beaten to death in the ensuing altercation. Following this, he started going to another crack home, a Northeast Houston apartment owned by 38-year-old Bonita Edwards, a widow without a job who had twin daughters, Annette and Burnett, who were 16 years old. To the dismay of Edwards' daughters, who had tried to move in with their grandmother out of fear, the flat was regularly used as a safe haven for drug addicts. White went to the flat on November 30 with the intention of using drugs and having sex with Bonita, but he got upset when she declined. Then he took out a knife and repeatedly attacked her, frightening her 2 daughters. After that, he went to the bedroom and essayed Annette before slitting her throat and stabbing her in the chest. He then went to the bathroom and did the same to Burnett. White killed the girls, then hurriedly fled after shoving a towel into Burnett's mouth and partially covering Annette's body with a blanket. The bodies were not found until December 2nd, when King Solomon, Edwards' worried boyfriend, visited the flat to see how they were doing. He asked the neighbors if they had seen Edwards or her girls when no one answered the door, and when they said they hadn't, he asked the maintenance worker to unlock it. Solomon quickly called the police after discovering Bonita and Burnett's bodies on the floor when he opened the door. Neighbor interviews provided little helpful information, but an examination of the crime site showed that there had been no forced entrance, suggesting that the victims probably knew the killer. The triple murder remained a cold case for nearly 6 years after the investigation failed to produce any credible suspects. White and a friend named Tecumseh Manuel tried to rob a convenience store in Houston in July 1995, killing the cashier, Ivan Pham. After both men were taken into custody for the murder, Manuel told detectives that White had allegedly admitted to him that he had killed the Edwards family in 1989. Consequently, he was questioned about the triple murder, and although White first denied any involvement, he took responsibility after seeing some of Manuel's interrogation. He claimed that when he and his friend Terrence Moore went to Bonita's apartment with the intention of having relations and using substances, she criticized both of them for not sharing the substances with her. After Moore stabbed Bonita, her daughters left their rooms to see how she was doing. After allegedly grabbing one of them each, White admitted to essaying one victim, while Moore proceeded to methodically stab both victims. When they were done, the two departed. When confronted with the fact that Moore actually died 4 months before the killings, despite his denials, White acknowledged that he had made up the tale and he was the only one to blame. His culpability was confirmed by later DNA and serology testing that found his blood and genetic material samples at the crime scene. A grand jury indicted White on May 28, 1996 for the killings of Annette and Burnett. He was convicted and given the death penalty 2 months later. His attempts to appeal his sentence were unsuccessful on multiple occasions. Due to its problematic history and the fact that a private company was unable to replicate the results, the Houston Police Department's crime lab's DNA tests were questioned in 2004. This occurred while the crime lab's record was being investigated for its high rate of errors and lack of supporting evidence. No solid reason was found to support the commuting of White's sentence when the investigation was concluded. The 180th District Court of Harris County scheduled the execution for January 28, 2015. His lawyers responded by contesting the request in an appeal, arguing that their client's low IQ, early trauma, and spotless criminal record should be sufficient grounds for having his sentence changed to life in prison. Furthermore, they contested the validity of the DNA test and his videotaped confession, claiming that samples taken from the blanket showed the presence of another man at the crime scene. The Texas Court of Criminal Appeals postponed White's case on January 27, the day before he was to be executed, in order to consider fresh arguments from White's lawyers. After the state won this appeal, Judge Deshaun Jones set a new execution date for October 1, 2024, on the request of Harris County District Attorney Kim Ogg's office. Prior to his execution on October 1, 2024, he was incarcerated at the Allen B. Polunsky Unit at West Livingston on death row. Garcia Glen White, 61 years old, was executed by the state of Texas on October 1st at the Huntsville prison facility. His final words were, "I apologize, and I pray that you can find peace, comfort, and closure in your heart for the wrong I have done and the pain I have caused you, and anybody else I have caused pain to. I'm sorry for all the pain I have caused." He then started singing a hymn called "I Trust in God" in a loud, powerful voice. He sang many lines that ended with the refrain, "I trust in God, my Savior of the world, the one who never failed." He concluded by thanking prison officials and guards for treating prisoners like human beings and urging family and friends to just keep pushing forward, keep loving one another. He breathed quietly a few times as the medications started to take effect, and then he started making noises that sounded like snores, some of which were loud. He gulped, burped, and snored softly once. After 17 minutes, he was declared deceased. As for his last meal, he didn't get to choose one because Texas doesn't offer special requests anymore. If you find the video interesting, please hit that subscribe button. The second execution, carried out in October, involved a man that clearly stated he was guilty and he wanted to be executed. Derrick Ryan Dearman, Alabama, October 17. 5 people, including a 5-month pregnant woman, were killed in a mass murder that took place in Citronelle, Alabama on August 20, 2016. All of them were murdered early in the morning in a private home west of the city in a rural region. Lanita Lester's brother owned it and she had taken refuge there. Her ex-boyfriend Derrick Dearman kidnapped her and her brother's baby and brought them to Leakesville, Mississippi. That same day, he let her go. Lester brought the baby back to Citronelle. She reported the killings to the police. This mass murder was the deadliest in Mobile County's history, according to investigators. After the crime, the house burned down a few weeks later. They already considered Dearman as a suspect when he turned himself in to the police station in Greene County, Mississippi, and was taken into custody. Around 4 a.m. on August 20, 2016, a male attacker broke into a house in the 1700 block of Jim Platt Road, which is located in a rural area west of Citronelle. He murdered 5 people while they slept, including 2 married couples and a 5-month pregnant lady. He used a range of weaponry, such as rifles and an axe. He abducted his ex-girlfriend, Lanita Lester, and her brothers and his wife's newborn. He brought them to his father's home in Leakesville, Mississippi, which is roughly 30 miles to the west. Later, he let them go. After Lester brought the baby back to Citronelle, Lanita proceeded to the police station and informed the authorities about the murders. She said that her ex-boyfriend Derrick Dearman had slain everyone at the house and kidnapped her. The 5 bodies were discovered at the crime scene by the police. They stated that processing the crime scene would require a lot of time. At first, it was thought that Lester had run away from Dearman, but he allegedly let her and the baby go. According to investigators, homeowners indicated that Derrick Dearman was on the property when they called 911 from the residence at around 1 a.m., a few hours prior to the killings. After responding to the residence, officers left after finding no sign of him on the forested property. In the beginning, investigators thought the killings were part of an attempted kidnapping or burglary and that the assailant had utilized an axe and many guns that were in the residence. 2 guns and a bladed weapon was discovered by the police at the house. It was said to be the deadliest mass murder in Mobile County's history. The house where the killings occurred was shared by the deceased victims, Joseph Adam Turner, Lester's married brother, who owned it and resided there with his spouse. According to reports, Lester went there to escape her Mississippi-based ex-boyfriend Derrick Dearman. Among the victims of the murder were Lester's brother Joseph and his spouse, another married couple where the woman was 5 months pregnant, and they were at the house at the moment. The victims were the following: Joseph Adam Turner, 26, Lester's brother; Shannon Melissa Randall, 35, Turner's wife; Robert Lee Brown, 26, Justin Caleb Reed, 23, Chelsea Marie Reed, 22, Justin's wife, and she was the one 5 months pregnant. Born in September 1988, Derrick Ryan Dearman surrendered to law enforcement in his hometown of Leakesville, Mississippi, which is roughly 48 kilometers west of Citronelle. According to reports, his father persuaded him to give up. Lanita Lester had an estranged relationship with Dearman. She had gone to her brother's house in Citronelle to seek refuge with him after leaving Dearman because of what she claimed to be an abusive relationship. Dearman's ex-wife characterized him as irritable, particularly when he didn't get his way. His marriage produced 2 children. He had accrued a long criminal record in Mississippi. Dearman was extradited to Mobile, Alabama on August 22 in order to stand trial. He allegedly said, "Don't do drugs." He apologized and claimed to have turned himself in after realizing what he had done while being led to an administrative facility. Later, he called the victims friends and apologized directly to Lester. The next day, he claimed to have been under the influence of methamphetamine when the murders occurred and attributed them to the drug's effects. Dearman was charged on August 31, 2016, with 2 counts of kidnapping and 6 counts of capital murder, one of which was for the unborn of Chelsea Reed in accordance with Alabama's fetal homicide law. He entered a not guilty plea to each and every count. First, because it was connected to an attempted burglary, and second, because 2 or more people were killed in the same crime, it was categorized as a capital murder case. A few weeks following the killings, the Turner residence was destroyed by fire. 2 defense lawyers designated by the court were assigned to Dearman. At the state's request, Circuit Judge Rick Stout ordered Dearman to undergo a mental evaluation in mid-August 2017, which the state of Alabama was to complete. 3 subjects were to be covered: Dearman's IQ, his mental state at the time of the crimes, and his ability to stand trial. During this period, one of his lawyers left the case. Dearman refused to have his competency and IQ evaluated since he had not entered a plea pertaining to either. The court rejected his plea to set restrictions on this kind of testing. After reviewing the test results, the judge was supposed to share them with the defense and prosecutor. Dearman eventually entered a guilty plea to the charges of kidnapping and capital murder in September 2018. Due to the capital murder allegations, he was still eligible for a jury trial in Alabama, where he faced a death sentence. Prior to submitting his plea, he had dismissed both of his court-appointed lawyers, and he was found competent to stand trial by the judge. The jury approved the death sentence after Dearman was found guilty on 6 counts of capital murder and first-degree kidnapping during the trial. On October 12, 2018, the court upheld this, and Dearman received a death sentence for these killings. According to reports, in April 2024, Dearman had given up on attempting to get his sentence overturned. His death warrant was approved by the Alabama Supreme Court on September 3, 2024, and his execution date was set for October 17, 2024. In a news release, the Alabama Department of Corrections detailed Dearman's actions up to his planned execution. On Wednesday, October 16, Dearman's day included several activities, as detailed in the release. He received visits from his father, his sister, and his spiritual advisor, the Reverend Jeff Hood. For breakfast, he accepted a meal along with an extra tray that included grits, 2 biscuits, apple jelly, eggs, ground gravy, and raspberry tea. Later in the day, he had a snack consisting of a cheeseburger and a Dr. Pepper. He chose to refuse his lunch meal, but accepted a dinner of chicken, cabbage, cornbread, and peas. Throughout the day, he made phone calls to his sister, a friend, his spiritual advisor, and his father. On Thursday, October 17, the day of his execution, Dearman was visited by a friend, his father, 2 of his sons, his brother-in-law, and his sister. Unlike the previous day, he did not make any phone calls. Observers noted that he consumed a Dr. Pepper, a sub sandwich, and a strawberry Sunkist. For breakfast, he ate oatmeal, eggs, 3 biscuits, orange juice, and brown gravy. His lunch consisted of macaroni salad, cornbread, corn, potatoes, green beans, carrots, and sloppy joe. His final meal was a seafood platter brought in from a local restaurant. At the time of his execution, corrections officers secured Dearman to a gurney and inserted needles into veins in both of his arms. At 6:01 p.m., an officer called out Dearman's name as part of a consciousness check, during which his arms were seen moving slightly. However, Corrections Commissioner John Hamm informed reporters that this movement did not indicate consciousness. Around 3 minutes later, Dearman seemed to stop breathing, and officials closed the curtains between the execution chamber and the viewing area at 6:08 p.m. The state officially pronounced his death at 6:14 p.m. When the curtains closed, his family sobbed. Dearman's last words were, "To the victim's family, forgive me. This is not for me, this is for you. I've taken so much. To my family, y'all already know I love you." A third execution planned was of a man accused of the most heinous crime, at least in my books, the murder of his own daughter. This, however, ended up being stayed just minutes after it actually happened. Robert Leslie Roberson III, Texas, October 17. Roberson was found guilty of capital murder and given the death penalty in 2003 after being charged with seriously abusing his 2-year-old daughter and killing her. Roberson was born on November 10, 1966 in Wood County, Texas. He was freed from prison in 2000 after being found guilty of burglary, larceny, and parole violations between 1991 and 1999 according to official documents. Robertson had 2 children from a failed marriage before 2002, and he also had a daughter with a different lady who was allegedly a sex worker and a chronic drug user. Nikki Michelle Curtis was born on October 20th, 1999, and was placed in the custody of her maternal grandparents. Robertson was given custody of Nikki after he underwent DNA testing and was found to be her biological father. Shortly after her birth, the baby was reported to have a number of chronic illnesses. 2 years after the conclusion of his most recent incarceration, Robertson took an injured Nikki to the hospital on January 31, 2002. He informed hospital officials that his daughter had fallen from her bed, had head injuries, and was unconscious when he woke up. 2-year-old Nikki Curtis was declared dead after hospital officials were unable to resuscitate her despite the medical intervention. However, the physicians and nurses thought that the injuries were not the result of a fall and speculated that child abuse may have been the cause. Thus, a police report was filed. Robertson was taken into custody the following day, and he was accused of murder, a crime that, according to Texas state law, carries a life sentence or the death penalty. A jury in Anderson County found Robertson guilty of capital murder on February 21, 2003, and he was given the death penalty. Robertson's execution was set for October 17, 2024, after the trial court in Anderson County, Texas, approved the death warrant for him on July 1, 2024. According to reports, Robertson was the first death row inmate convicted of shaken baby syndrome to have his execution planned within the United States. His case faced intense discussion with regards to whether his murder conviction and death sentence should stand in light of the outdated science of shaken baby syndrome when the execution date was announced. The announcement of Robertson's execution date further heightened the lingering concerns about his alleged innocence. In an effort to prevent Robertson's execution, lawmakers and law enforcement officials overwhelmingly supported the commutation of his death sentence. Reverend Brian Wharton, a former police officer who looked into the Robertson's case and whose testimony helped get Robertson on death row, stated that he believed that the conviction or sentence should not have occurred if proper investigations had been conducted in the case, particularly since Robertson's autism was not diagnosed. Robertson's appeal against the death sentence was given a second hearing on October 8, 2024. However, the Texas Court of Criminal Appeals denied his case on October 11, 2024. On October 16, 2024, the Texas Parole Board voted unanimously 6-0 to not recommend Robertson's sentence be commuted or his execution delayed. The scheduled execution of Robertson was halted after the Texas Supreme Court issued a partial stay late Thursday night. The stay was issued just over an hour before his death warrant was due to expire, following a tense legal battle between the state and Robertson's defenders over his fate. The Supreme Court's decision came swiftly, following a split decision by the Texas Court of Criminal Appeals earlier that night, which had overturned the lower court's order to stop the execution. While the court order allowed his death warrant to lapse at midnight on Thursday, the legal dispute is ongoing. A new execution date could be scheduled either after his potential testimony before lawmakers next week or sooner if the court orders it. The delay in Robertson's execution began on Wednesday when the Texas Committee on Criminal Jurisprudence voted to subpoena him as they reconsider the validity of his conviction. 3 people were scheduled to be executed in the month of November. Richard Bernard Moore, November 1st, South Carolina. He was found guilty of killing James Mahoney, a convenience store employee in Spartanburg, South Carolina, in September 1999. Moore's case gained worldwide attention in 2022 when, in accordance with the state's new capital sentence rules, he chose to be executed by firing squad instead of being put to death by lethal injection. Moore was raised in Detroit, Michigan. He battled drug addiction and resorted to burglary as a means of funding his habit. Because of his vices, he was found guilty of theft and possession of weapons in the 1980s. He and his partner, Linda Bird, relocated from Michigan to Spartanburg in 1991. Later, the couple had 2 kids together. While attempting to steal Michelle Crowder's purse in 1991, Moore struck her in the neck. Because she landed on the purse, Moore kicked her repeatedly in the head and back. But that attack did not end there, because Moore also assaulted Crowder's fiancée so badly that he had to be taken to the hospital when he showed up to help her. Crowder would eventually testify during Moore's murder trial's sentencing phase. Valerie Wisniewski, another Spartansburg resident, said that Moore robbed her when she was employed at a shoe store. In 1997, Moore also entered a guilty plea to high and aggravated assault and battery for attacking a lady. He was a violent man, and that only escalated as time went by. Early on September 16, 1999, Moore went into the convenience store Nicky's. He planned to rob the business in order to purchase drugs, and he was unarmed. Terry Hayden, an eyewitness to the incident, and James Mahoney, a 42-year-old clerk, were inside the business. Hayden watched Moore move toward the store's cooler while he was playing video poker. Then he heard Mahoney yell at Moore and questioning his actions. Hayden looked over and saw Mahoney and Moore fighting. Mahoney pulled out a gun, but Moore managed to take it from the clerk and pointed it to Hayden, asking the witness not to move. Moore then attempted but failed to shoot Hayden. Pretending to be dead, Hayden collapsed to the ground. A few more rounds were fired after Mahoney pulled out a second firearm. Moore shot Mahoney in the chest, then Mahoney shot Moore in the arm. Moore departed the store and took off in his pickup truck after pacing around it and leaving a trail of blood in his wake. Then Hayden stood up and saw Mahoney on the floor, face down, with a gun next to his hand. Mahoney passed away from a gunshot wound to the chest a few minutes after Hayden called the police. Moore stole $1,408 from the business. While monitoring the neighborhood after Moore left the business, Deputy Bobby Rowlands, who was searching for him, heard a loud bang. About 1.5 miles from the scene of the incident, Moore had backed his pickup truck into a telephone pole. Moore was seated in the back of the truck, bleeding from the gunshot wound to his left arm, when Rowlands got close to the car. Moore admitted to the crime as Rowlands yelled for him to turn himself in. The stolen cash was discovered on the truck's front seat in a blood-stained bag. Shortly before daybreak, the weapon that Moore had stolen from Mahoney was discovered on a neighboring highway. After being transported to Spartanburg Hospital, Moore received medical attention for his wounds. He was subsequently charged with murder, assault, and battery with intent to kill and armed robbery. In October 2001, Moore was put on trial. He was convicted on all counts by the jury and found guilty. The jury recommended the death penalty in a different sentencing hearing. On October 22, 2001, Moore was formally given the death penalty for Mahoney's murder. The first gun was drawn by Mahoney, and Moore said he shot him in self-defense. According to his supporters and appellate attorneys, the crime did not warrant the death punishment. Given that Moore didn't have a firearm with him, his attorneys contended that he didn't mean to kill anyone when he entered the business unarmed. He seized the gun from Mahoney, and it was circumstantial rather than intentional. One contentious element of Moore's trial was the absence of any African Americans on the jury that found him guilty. Moore was the only death row inmate in South Carolina that had such a jury. Circuit Judge Gary Clary set his execution date for January 22, 2002. But at the time, prosecutors admitted that Moore would not be put to death until after years of appeals. Another execution date for Moore was set for December 4, 2020, after he ran out of appeals. However, the state lacked the lethal injection medicines necessary to carry out his execution. Moore had the option of dying by electric chair or by lethal injection. He refused to choose any of them, thus the primary method of lethal injection had to be used to end his life. His execution was postponed because the state lacked the necessary medications. As a result, once the drugs required for lethal injection were not obtained, lawmakers in South Carolina sought to add the alternative of execution by firing squad in an effort to recommence executions. A bill offered prisoners the options of being executed by firing squad or electrocution in the event that lethal injection medications were not available. The state said in March 2022 that it had completed creating procedures for firing squad executions. The date of Moore's punishment was set for April 29, 2022. He opted to be put to death by firing squad on April 15 rather than by electric chair. The South Carolina Supreme Court temporarily stayed the execution on April 20. At the time of Morse's scheduled execution on April 29, the outcome of two lawsuits that Morse's lawyers had previously filed contested whether South Carolina's execution practices, including the use of the electric chair, were unconstitutional and whether Morse's sentence was suitable for the level of severity of the crime. The court decided on July 31, 2024, that the firing squad and electrocution methods of execution are constitutional. Another prisoner on South Carolina's death row, Freddy Eugene Owens, was set to be executed on September 20, 2024. Moore and 4 other death row inmates were supposed to be executed at a later date. A court order had been issued directing that the 5 be executed 5 weeks apart. The state's 13-year moratorium on the death penalty was ended when Owens was executed by lethal injection as planned. Morse's new death warrant, which called for his execution on November 1, 2024, was issued on October 4. He had 2 weeks to decide if he would be executed by lethal injection, firing squad, or electrocution. The state would put him to death in an electric chair if he didn't choose a method of the 3. Moore decided to be executed by lethal injection. He appealed, contesting the governor of South Carolina's exclusive authority to grant a pardon. He said that the state parole board, not the governor, should determine whether to give mercy to a death row convict, since Henry McMaster, a former prosecutor, was unable to make such a judgment impartially. A federal judge denied this, holding that the governor of South Carolina should be the only one with the authority to decide whether to give or deny death row convicts clemency. A campaign for clemency was also launched in an attempt to have Morse's death sentence commuted to life in prison. Lyndall Moore, Morse's son, requested that the governor spare his father's life, claiming that his father had changed and had never meant to kill when he was only thinking about thievery. Lyndall said that he and his siblings first learned of his father's crime when he grew older. Lyndall was just 5 years old when his father was imprisoned for the murder of James Mahoney. He recalled Moore as a typical individual who aspired to be a good father and said that Moore had a typical life in southeast Michigan before doing drugs and getting into trouble with the law. Moore made a concerted effort to establish a strong relationship with his son. Moore had always behaved well while incarcerated and had only broken the law twice. Alexandria, Morse's daughter, who is married and has 2 kids of her own, said her father had changed his ways and that she hoped his life would be saved since he had tried to be a good influence to those he had associated with while he was on death row. Morse's last plea to hold his execution was considered by the U.S. Supreme Court on October 28, 2024. He made claims that the prosecution allegedly excluded African American potential jurors from the jury selection process, that his trial as an African American defendant was handled with a jury composed of 11 white and 1 Hispanic juror, and that this could compromise the fairness and impartiality of a capital trial. Consequently, the public's trust in the criminal justice system was weakened. Morse's execution proceeded when the U.S. Supreme Court refused to grant a stay of execution. Moore requested the governor's clemency as a last resort to avoid the death penalty. After agreeing that Moore had changed, 2 former jurors and retired Circuit Court Judge Gary Clary, who had given Moore the death sentence back in 2001, joined forces to ask the governor for clemency. They thought he wasn't deserving of being put to death. According to former Corrections Director John Osmond, a strong advocate of the death penalty, Moore was one of several reliable and respected inmates on death row. And when compared to those who received life sentences for crimes more serious than his own, he was not one of the worst offenders who should have been executed. Osmond requested a commuting of Morse's death sentence to life in prison, but McMaster decided not to grant clemency. Prior to the execution, Morse's lawyer read one last statement from his client in which he thanked his children, grandchildren, and other supporters and apologized to Mahoney's family. To the family of Mr. James Mahoney, I am deeply sorry for the pain and sorrow I caused you all. To my children and granddaughters, I love you and I am so proud of you. Thank you for the joy you have brought to my life. To all of my friends, family, and friends, new and old, thank you for your love and support. At 6:02 p.m., Moore closed his eyes. At 6:04 p.m., he stopped breathing after taking short breaths. Moore was pronounced dead a minute after a doctor checked his pulse at 6:23 p.m. His final meal was a medium-cooked steak, fried catfish and shrimp, scalloped potato, green peas, broccoli with cheese, sweet potato pie, German chocolate cake, and grape juice. Karey Dale Grayson, November 21, Alabama. Vicky W., age 37, was dropped off by a friend on I-59 close to Chattanooga, Tennessee, on the evening of February 21, 1994, so she could hitchhike to her mother's house in Louisiana. She was spotted traveling by 4 teens who had been consuming alcohol and using drugs: Kerry Grayson, Kenny Loggins, Trace Duncan, and Louis Mangione. Instead of taking her to Louisiana as they had promised, they drove her to a secluded area while pretending to pick up another vehicle. When the 4 teenagers arrived to the woodland, they started drinking and hurled their beer bottles at W as she attempted to flee. After successfully containing her and tackling her to the ground, the males began to physically abuse W by continuously kicking her across her body. In the early hours of February 22, 1994, Grayson and one of his younger pals, Loggins, stood on W.'s throat when they realized the victim was still alive. W. gurgled blood and died as a result. Following W.'s murder, the 4 took her corpse and belongings in the back of a pickup truck and went to Bald Rock Mountain, where they essayed her and stole her clothing and ring before tossing her body down the cliff. In order to clean the truck and get rid of the bloodstains, the teens left the body behind and drove it to Pell City. They dumped W.'s bags in the forest as well. Mangione was taken home by the 4 after they drove back to Birmingham. Grayson, Duncan, and Loggins then went back to Bald Rock Mountain, where they disfigured W.'s body by stabbing and cutting it 180 times. They also amputated W.'s fingers, thumbs, and a portion of her lung. After finishing the gory task, the 3 of them dozed off in the vehicle and spent the night in Birmingham. By daybreak, Grayson's girlfriend discovered her boyfriend and the other 2 still sleeping in the vehicle, covered in blood and dirt. Grayson told his girlfriend that all the blood was from a dog when she questioned him about the stains. 3 rock climbers found what was left of W.'s body on February 26, 1994, 4 days after she was murdered. According to an autopsy, W.'s death was caused by blunt force trauma to the head, with asphyxiation perhaps playing a role. All 4 young people were detained and accused of torturing and killing Vicky W. by April of 1994. Louis Mangione, Karey Dale Grayson, Kenneth Loggins, and Trace Duncan were tried in separate Alabama state courts between November 1995 and February 1996. Trace Duncan was the first of the 4 to be found guilty of murder on November 2, 1995, 3 days before his 18th birthday. The jury suggested that Duncan be given the death penalty. His formal sentencing date was set for January of 1996. On November 18, 1995, Louis Mangione became the second criminal to be found guilty. However, the jury recommended that Mangione be sentenced to the minimum punishment of life in prison without the possibility of parole, sparing him from the death penalty. Kenneth Loggins' trial was originally scheduled for September 1995, but it was postponed until November 27, 1995, when the psychologist failed to provide a report in time to assess Loggins' mental state at the time. After pleading not guilty by insanity, Loggins was found guilty in December of the same year, and 10 of the jury's 12 members suggested that Loggins be executed. The trial of Karey Dale Grayson, the last of the 4 defendants in the W.O. murder case, started on January 29, 1996. 4 days later, on February 2, 1996, Grayson was found guilty. 6 days later, the jury returned with the unanimous recommendation of a death sentence for Grayson after deliberating for just 15 minutes. The prosecution then attempted to have all 4 young people executed for the murder of W.O., emphasizing that the heinousness of the crime and the gore of W.O.'s demise justified the execution of all 4 lads. On March 8, 1996, a sentencing trial for the 4 defendants was planned. Circuit Judge Mike McCormick acted on the jury's recommendations in the cases of the 4 defendants on March 8, 1996. While he sentenced the other 3 accused, Grayson, Duncan, and Lodgens, to death, he spared Mangione from the capital penalty and instead ordered that he be imprisoned for life without the possibility of release. Louis Mangione was 16 at the time of the murder, Kenneth Lodgens and Trace Duncan were 17, and Grayson was 19. The Roper v. Simmons case was considered by the U.S. Supreme Court in 2005, and the majority decision of 5-4 formally declared that it was illegal to execute criminals who were younger than 18 at the time of their offenses. This decision affected numerous cases involving juveniles on death row, such as the 1994 W.O. murder case involving Kenneth Lodgens and Trace Duncan, who were both minors at the time of the murder and were therefore eligible to request a reduction of their death sentences to life in prison. Trace Duncan's death sentence was changed to life in prison without the possibility of parole in April 2005. Kenneth Lodgens' death sentence was commuted to life in prison without the possibility of parole on January 28, 2006, when an Alabama state court accepted his plea. Since 2005, Lodgens was the 13th young person on death row to have their sentence lowered, and he also appealed his life sentence 5 years after he was resentenced in 2011, arguing that it was unlawful to sentence children to life in prison without the possibility of parole. However, his appeal was denied. Ultimately, in 2012, Alabama changed its juvenile life imprisonment laws to make it unconstitutional for minors to serve mandatory life sentences without parole. The new laws also gave judges the authority to decide whether or not to grant parole to juveniles serving life sentences, taking into account previous court decisions. Kenneth Lodgens, Trace Duncan, and Louis Mangione, who were all involved in the W.O. murder, were among the numerous young people given life sentences without parole. Following a series of resentencing hearings, Mangione and Duncan were given the opportunity to be released on parole after at least 35 years, with their first parole hearings scheduled for 2029. Lodgens, whose hearing was held in 2018, was not granted that option for parole. Because both Duncan and Lodgens were resentenced, the only convicted person still on death row for killing Vicky W.O. was Karey Dale Grayson, who was 19 at the time of the murder. Grayson took his case to federal court and filed a plea of habeas corpus in the Northern District of Alabama after he had exhausted all state appeals in 2006. However, the motion was denied in September 2009. Grayson's appeal was denied by the 11th Circuit Court of Appeals in October 2010, and the U.S. Supreme Court dismissed his appeal and upheld his death sentence a year later. Grayson was initially set to be executed by lethal injection on April 12, 2012, but the Alabama Supreme Court delayed his execution after his attorneys filed an appeal contesting the modification of drug use in Alabama's lethal injection procedures. Grayson was one of 5 death row inmates who sued the state in 2015 to stop them from using high amounts of midazolam in lethal injection executions. Although Grayson remained on death row, Alabama law permitted the state to execute people by lethal injection or nitrogen gas inhalations as early as 2018, allowing Grayson to select either method to carry out his upcoming execution, which had not yet been scheduled. The Attorney General's office filed a motion to approve Grayson's second death warrant in June 2024, 5 months after Alabama's first nitrogen gas execution. The state representatives requested that Grayson be executed using nitrogen gas. Back in 2018, that's what he selected as a method of execution. Of course, at that time, it was very far-fetched that the state would ever employ nitrogen hypoxia to put inmates to death. On August 15, 2024, the Alabama Supreme Court approved the death warrant for Grayson, and the court order was issued for the Alabama Governor Kay Ivey to authorize his death warrant. Grayson's death sentence was set to be carried out via nitrogen hypoxia on November 21, 2024, 5 days after the Supreme Court approved his death warrant. This was about to make him the third person in Alabama to face execution by nitrogen gas, following Kenneth Eugene Smith on January 25 and Alan Eugene Miller on September 26. Citing possible issues with the new execution technique, Grayson's attorneys filed a motion to halt the scheduled execution. They pointed out that witness accounts claimed that Kenneth Eugene Smith, the first convicted murderer to be executed using this technique in Alabama, had suffered seizure-like spasms, which could be considered cruel and unusual punishment because it did not ensure Grayson would die painlessly. They also asked to amend the procedure to allow Grayson to receive a sedative before the execution. All requests were denied. At 6 p.m. on Thursday, the execution was held at the William C. Holman Correctional Facility in Atmore. In his final remarks, Grayson cursed the prison warden. Grayson clenched his hands tightly, gasped deeply, shook his head violently, and pulled against his restraints as soon as the nitrogen started to flow. About 6 minutes after the gas began to flow, at 6:18 p.m., he seemed to lose consciousness. Grayson's last meal was soft tacos, beef burritos, tostada, chips, guacamole, and Mountain Dew Blast. Vicky DeBlios's daughter Haley was just 12 years old when the murder occurred. Even if her mother's death impacted her life in more ways than one, she did not agree with Grayson's execution. Something that she said that stuck with me was how she wondered what positive impact Grayson could have had in society if the system wouldn't have failed him as a little boy that was abused and neglected. Thomas Creech, November 13, Idaho. For a second time this year, his execution was stayed. Serial killer Thomas Eugene Creech was found guilty of 2 killings in 1974 and given the death penalty in Idaho. 2 years after the appeal, the sentence was lowered to life in prison. Because of a murder he committed in 1981 while incarcerated, he was returned to Idaho's death row. Creech himself admitted to 42 murders in several states, some of which reportedly implicated the Church of Satan and Hell's Angels. Although the majority of his other confessions have not been verified, authorities think there is compelling evidence connecting Creech to 7 more murder victims, 2 of whom he was found guilty of. The San Bernardino County Sheriff's Department concluded in January 2024 that Creech killed Daniel Walker in what was a cold case. Creech was the state's longest-serving death row inmate as of 2024. His execution was postponed after an unsuccessful attempt on February 28, 2024. His new execution date of November 13 had been scheduled, but on November 6, a federal judge halted his execution to allow for legal challenges. He is still on death row. 3 people have been executed in December. Christopher Leroy Collings, December 3, Missouri. He was on death row for the murder of a little girl. 9-year-old Rowan Ford, a 4th grader at the time, was last seen at her house in Stella, Missouri on November 3, 2007. Ford was reported missing when her mother, Colleen Munson, was unable to locate her. Both FBI and the police were involved in the search for answers. Ford's body was discovered within a cave in a rural area of McDonald County, Missouri, 6 days after she vanished. Covered in leaves and rubble, she was naked from the waist down and wearing just 1 sock when she was found. In addition to bruises on her private parts, Ford had a ligature mark around her neck. According to an autopsy report, the girl was also essayed before she passed away, and the cause of death was strangulation. 2 individuals were taken into custody. One of them was Ford's stepfather, David Wesley Spears, 25, and the other was Christopher Leroy Collings, 32, Spears' friend. Collings had previously spent many months in the summer and fall of 2007 living with Ford's family before the murder. Collings slept in the basement, and the little girl looked up to him. In late October 2007, Collings moved to his family's farm near Wheaton, where he lived in a mobile trailer. He was divorced from his wife, with whom he had 3 children, who all lived in Arkansas with their mother. Both men admitted to their involvement in Ford's murder. After drinking too much, Collings kidnapped the young girl and imprisoned her in his trailer. After Collings essayed Ford and the girl saw his face as he was about to drive her home, Collings panicked and used an old pickup truck's coil of chicken house rope to strangle Ford to death. Spears was implicated because he confessed in assisting Collings in disposing of his stepdaughter's body. Spears would later report his stepdaughter missing after the horrible acts, claiming that Ford might be at a friend's house. However, Spears' suspicious behavior and demeanor during the search for Ford ultimately led to police naming him as a suspect, and Collings was apprehended and arrested for the essay and murder. It was also stated that Spears was the one that guided the police to the location of Ford's body. Following both men's arrests, Ford's mother filed for divorce. The little girl was regarded by many as a standout student who was adored by her classmates and teachers. Collings and Spears both entered not guilty pleas, but the prosecution formally declared in May 2008 that they intended to pursue the death penalty. Collings was arraigned for a later trial because he waived his right to a preliminary hearing prior to the case going to trial. Both Spears and Collings were given a change of venue and went on trial separately in Berry County and Phelps County respectively as a result of the case's widespread media coverage. Collings was initially put on trial before a jury in a Phelps County Circuit Court on March 12, 2012, exclusively on the charge of first-degree murder. While awaiting trial for the murder of his stepdaughter, Spears himself testified in court along with forensic evidence and Collings' recorded confession. Collings was convicted of Rowan Ford's first-degree murder on March 20, 2012. And the defense argued against the death sentence and requested life in prison, pointing out that Collings had been diagnosed with both severe disorganized dissociative attachment disorder and intermittent explosive disorder, as well as having a dysfunctional family history and a tragic upbringing. The prosecution had sought the death penalty after highlighting the case's aggravating circumstances. Ford's friends, family, and teachers appeared in court to testify about the aftermath and impact of her passing on their lives. Collings' father also appeared as a witness on behalf of his son, declaring his love for him regardless of the consequences. After 48 minutes of deliberation, the jury returned with a verdict that sentenced Collings to death for the murder of Ford. The jury's decision stated that Rowan Ford's murder was outrageously and intentionally vile, horrible, and inhumane. Also, they said that Collings killed Ford in order to prevent her from going to the authorities for what happened to her. After the prosecution and defense reached a plea deal agreement on September 26, 2012, Spears pleaded guilty to endangerment of a child's welfare and cover-up of the crime, and the prosecution dropped the murder charge against him. The prosecution said that more research had not definitively established Spears' involvement in Ford's murder and essay, and that his role was minimal in comparison to Collings, who was judged to be the case's primary criminal. Spears received an 11-year prison sentence for the counts he acknowledged in court. He was released in 2015 after staying a little over 7 years behind bars. Christopher Collings appealed his death sentence to the Missouri Supreme Court in January 2014. The appeal was denied on August 19, 2014. Collings' second appeal was denied by the Missouri Supreme Court on March 6, 2018. Collings took his case all the way to the federal courts after he had exhausted all of his state appeals. His appeal was initially denied by the U.S. District Court for the Eastern District of Missouri on September 30, 2022. On January 12, 2023, Collings filed a follow-up appeal, which was later denied by the Eighth Circuit Court of Appeals. Collings' last appeal was denied by the U.S. Supreme Court on April 1, 2024. After he had exhausted all of his appeals, Attorney General Andrew Bailey petitioned the Missouri Supreme Court on April 5, 2024, seeking permission to set an execution date for Collings. If the Missouri Supreme Court issues a death warrant, the execution date would fall between 90 and 120 days after the court order, according to Missouri state law. Collings' death warrant was approved by the Missouri Supreme Court on August 13, 2024, and his execution date was set for December 3, 2024. Collings was the fourth Missouri condemned felon set to be put to death in 2024. His request to have his execution postponed was denied by the U.S. Supreme Court on November 12, 2024. His attorneys and civil organizations requested clemency on his behalf in the final weeks before his scheduled execution. On the grounds that the death penalty infringed upon the sanctity and dignity of human life, the Missouri Catholic Conference requested that State Governor Mike Parson to pardon Collings and commute his execution sentence to life in prison. Nevertheless, Collings's last attempt to prevent his death was denied by the U.S. Supreme Court on December 2, 2024, the night before his execution. Parson further stated that he would not pardon Collings and permitted the execution to proceed. Rowan Ford's 35-year-old sister, Ariane Max, who was 18 when Ford passed away, reacted to Collings's planned execution by saying that Rowan was a ray of sunshine and that her death was heartbreaking because she was the youngest of 5 siblings in the family. Christopher Leroy Collings, 49, was executed by lethal injection at the Eastern Reception Diagnostic and Correctional Center on December 3, 2024. Collings apologized for the suffering he had caused and conveyed regret and acceptance of responsibility for the crime in his final remarks. He received 1 dose of pentobarbital and was declared dead at 10 minutes after 6 p.m. This was his last written statement. Right or wrong, I accept this situation for what it is. To anyone that I have hurt in this life, I am sorry. I hope that you are able to get closure and move on. Regardless which side of this situation that you are on, you are in my prayers, and I hope to see you in heaven one day. For his final meal, Collings chose a bacon cheeseburger, breaded mushrooms, tater tots, and a chef salad. Joseph Corcoran, December 18, Indiana. After a 15-year moratorium on executions in Indiana, Corcoran became the first individual to be put to death in the state. He was on death row for the 1997 quadruple murder of his brother, his sister's fiancé, and 2 of their friends at his house in Fort Wayne. Back in 1992, he was also suspected of killing his own parents, but he was eventually acquitted of all charges. Joseph Edward Corcoran was born on April 18, 1975, in Fort Wayne, Indiana. He was raised in Hamilton with his parents, 2 sisters, and 1 brother before they relocated to Ball Lake in Steuben County. Corcoran's mother, Catherine, was a stay-at-home mom who worked as a nursing assistant in Fort Wayne in the 1980s and attended business school briefly. Corcoran's father, Jack, was a former Marine who worked in an electronics company after leaving the service. During his teenage years, Corcoran attended Hamilton Junior-Senior High School. It was stated that he did not get along well with his parents, who were excessively harsh with him. Although Corcoran and his brother James had a tense relationship and James frequently made fun of him, Corcoran also looked up to James because James had been a Marine for 8 years. Corcoran was described by his family and neighbors as a recluse who had no friends. Corcoran found employment in New Haven as a machine operator. However, his indictment for the 1992 double murder of his parents disrupted his sophomore year of high school. According to reports, Corcoran lacked the capacity for learning in school. Even though he was smart and had a rapid grasp of electronics and how they worked, he struggled in school and ended up with a C average for his grades by the time he dropped out. Corcoran also collected firearms and made bombs as a pastime. In his late teens and early 20s, Corcoran was able to make and set off a number of tiny explosives in the forest. By the time he was 22, he had accumulated 32 different kinds of firearms, primarily handguns, rifles, and shotguns. Joseph Corcoran was accused of killing his parents, Jack Corcoran, 53, and Catherine Corcoran, 47, on April 14, 1992. His parents were discovered dead inside their house at approximately 8:30 in the morning, having been shot by a shotgun. According to the evidence, Corcoran most certainly used a 12-gauge shotgun to kill his parents. They allegedly burned his music recordings, forced him to attend church, sold a car he assumed would be his, and he felt like they were too harsh with him. His fellow students also said that at some point, Corcoran had offered them $200 and a firearm to kill his parents. Nevertheless, no concrete proof of Corcoran's guilt for the double murder was discovered, and the evidence against him was just circumstantial. The jury found insufficient evidence, and he was acquitted during a 5-day trial on November 16, 1992. Corcoran was relieved to be acquitted, and like his father, he wanted to finish high school and enlist in the Marines, according to Kim Corcoran, one of his 2 sisters. Even though the case is still open for regular reinvestigations, it has not been solved yet. In the 5 years following his acquittal, Corcoran, who never finished high school, moved in with his siblings who helped him in obtaining a variety of occupations, such as those as a chef and dishwasher. 5 years after he was accused of killing his parents, Joseph Corcoran killed his brother and 3 other men in a quadruple murder on July 26, 1997. Corcoran and his brother James Corcoran, who was 30 years old, were inside their Fort Wayne, Indiana home. Their sister Kelly Nieto and her 32-year-old fiancé Robert Scott Turner lived with them. That day, the residence was also occupied by friends Douglas Stilwell, 30, and Timothy Bricker, who was also 30. At the time, Corcoran's sister was not at home and was at a store nearby. In the living room, Turner, James, and his pals were eating pizza and watching TV. According to the prosecution, Corcoran heard people in the living room discussing his supposed role in his parents' murder. This infuriated him, so he loaded a semi-automatic rifle, carried it into the living area, and transferred his niece, who was 7 years old, into an upstairs bedroom to shield her from the gunshots. Bricker, Turner, and his brother were shot by Corcoran. Stilwell managed to avoid the initial assault and made an attempt to flee, but before he could do so, Corcoran shot and killed him as well. After exiting the residence, he requested a neighbor to contact the police. The 4 men were dead when the police came, but Corcoran's niece was uninjured in her bedroom. In the attic, the authorities also found around 30 guns. Upon learning of the killings, Corcoran's sister told the media that she was convinced Corcoran was responsible for the 1992 murders of their parents because he had killed both her other brother and her fiancée. She and James had previously strongly defended him in court. 2 days after the Fort Wayne killings, on July 28, 1997, Joseph, then 22 years old, was charged with 4 murders, 1 for each of the victims. Corcoran was convicted on all 4 counts of murder on May 22, 1999. 2 days later, the jury returned with its judgment, unanimously recommending that Corcoran be given 4 death sentences for each of the 4 murders. The United States Supreme Court denied Corcoran's last appeal on July 8, 2016, meaning that he had exhausted all of his appellate options. This allowed Corcoran to be executed on a date to be determined. After the state was able to acquire the medications needed for lethal injection executions, Attorney General Todd Rokita declared on June 26, 2024, that he would be submitting a move to the Indiana Supreme Court requesting an execution date for Corcoran. A 15-year moratorium on all outstanding executions in Indiana since the 2009 execution of Matthew Eric Wrinkles in connection with a triple murder case was in place at the time the appeal was filed. State officials affirmed that pentobarbital would be used to kill condemned offenders with a single drug lethal injection in all upcoming executions in Indiana, including Corcoran's. Eric Holcomb, the governor of Indiana, backed the state's decision to resume executions, saying that justice should be done and that he supported the use of the death penalty for serious offenses. There were just 3 instances of clemency being granted to the condemned in Indiana since the reinstatement of the death penalty in 1976, and Corcoran still had this last option to ask the governor for clemency in order to commute his death sentence to life in prison. Lawyers claimed that Corcoran's death sentence should not be carried out because he had been mentally ill and had been suffering from paranoid schizophrenia for a number of years. They also disclosed that Corcoran's symptoms continued to exist while he was on death row, including his delusions of having an involuntary speech disorder, being tortured daily by prison guards using an ultrasound machine, and having conversations with people he only saw in his hallucinations. On September 11, 2024, the Indiana Supreme Court accepted the death warrant of Corcoran, scheduling him to be executed before dawn on December 18, 2024. In addition to drafting a clemency plea for the Indiana Parole Board, Corcoran's attorneys were submitting their last court appeals. However, the petition was never filed because Corcoran allegedly refused to sign it, stating that he intended to die. Using Corcoran's refusal to sign the petition as evidence that he thought his death would cure his mental illness, which allegedly prevented him from making logical decisions to challenge his death sentence, Corcoran's attorneys contended that he was not competent enough to be executed. The U.S. Supreme Court dismissed Corcoran's final appeal on December 17, 2024. He was put to death in the Indiana State Prison by lethal injection early on the morning of December 18, 2024. At 12:44 a.m., 8 minutes after receiving a single dose of pentobarbital, he was declared dead. According to reports, Corcoran's final meal was ice cream from Ben & Jerry's. A farewell meeting with Corcoran's family, including his wife Tahina, whom he married while incarcerated, was permitted. When asked if he had any final words, he said, "Not really. Let's get this over with." Kevin Ray Underwood, December 19, Oklahoma. He was on death row for the murder of a 10-year-old girl. Authorities were looking for Jamie Rose Bolin, a 10-year-old girl who had vanished and for whom an Amber Alert had been issued. Underwood, who lived in the same apartment complex as Bolin, was arrested on April 17, 2006. Underwood told Oklahoma detectives and FBI officials that he had killed Bolin and tried to sever her head off. "Go ahead and arrest me. She is in there. I chopped her up." Bolin's body was discovered in his bedroom closet, concealed inside a large plastic container after Underwood's admission. According to Purcell Police Chief David Tompkins, Underwood's fantasies to kidnap a person, essay them, torment them, kill them, chop off their head, drain the body of blood, essay the corpse, devour the corpse, then dispose of the parts and bones, came to fruition with Bolin's murder. Underwood was found guilty of killing the little girl by striking her with a wooden chopping board. Police reported finding barbecue skewers and meat tenderizers at the scene, which they believe were meant to be used on the victim's body. A jury found him guilty of first-degree murder on February 29, 2008. On March 7, 2008, a jury recommended the death penalty. Given his lengthy history of abuse and severe mental health conditions such as autism, obsessive-compulsive disorder, bipolar and panic disorders, post-traumatic stress disorder, schizotypal personality disorder, and other deviant sexual paraphilias, Underwood's lawyers had argued that he should not be executed. The prosecution maintained that although mental illness affects a large number of people, it does not excuse the abuse of children. On the morning of December 19, 2024, his 45th birthday, Underwood was executed via lethal injection at the Oklahoma State Penitentiary. He was pronounced dead at 10:14 a.m. While strapped on a gurney inside the death chamber, Underwood expressed regret to both his own and Jamie's families. His last words were, "The decision to execute me on my birthday and 6 days before Christmas was a needlessly cruel thing to do to my family. But I am very sorry for what I did, and I wish I could take it back." His last meal was chicken fried steak, mashed potatoes and gravy, pinto beans, a hot roll, a cheeseburger and fries with ketchup, and cola from the canteen. Please hit that subscribe button if you like my channel. See you next time. Bye bye.